Madam, my lord, pardon to mention one criminal appeal for bail kindly taken in next week on US and bail and during trial.
Give it.
Not just this is a lease matter where the petitioner along with 5 others applied for lease since 2022 and stay is in favor of me, but the lease period will expire, your lordship. It was for 5
If it
years.
was given.
Tax admission land application.
Within list item number 69, my lord. Taken on my lord.
See that.
Within list item 16.
You see that we have
Land
to
acquisition.
create your shit.
Weekly list item 16. Contempt matter
69.
69.
Land acquisition matter, my lord.
Yeah, weekly list.
Wants to demolish the house of the 16.
Actually, let us finish this supplemented list first. And
Problem.
what is the urgency in the matter?
The opposite party wants to demolish the house of the petitioners, my lord. No stay in there, means.
You have made unauthorized construction.
No, my lord.
Then
ଜମି ଗୁଡାକ ଆମର ରୋଡ କରିବା ପାଇଁ ନେଇ ରାସ୍ତା କରିବା ପାଇଁ ଜମି ଆମ ଘର
ମାନେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ରାସ୍ତା କରୁଛନ୍ତି ତ ନେଲେ ଆପଣଙ୍କୁ ତ ପଇସା ଦେବେ
ଦେଇନାହିଁ ବନାନ୍ତି
ରିଜେଣ୍ଡର ବି ଅଛି
is a matter of supplement. It will come tomorrow in the supplement.
Supplemental list, item number 1.
Made please also. So this is that matter which I amended the REIT application and consolidated copy has been given. The other day it was not there with the government.
You have received it.
This is in record only. I don't have it in typing. I can access it through.
Okay. Yes, Mr. Please.
But if you also kindly appreciate that this matter, since 93, actually the quarter was allotted. There was a scheme of the Router Steel Plant. That scheme relates to scheme for leasing of housing to employees of the scheme 2003. On that basis, the lease of 33 years, a tripartite agreement was executed. Because the government granted the property to RSP and RSP granted lease in favor of the party. It was a tripartite agreement, Annex 2.
Yeah.
So it was a small quarter, in fact, with 880 square feet. So I applied for renovation of the same by additional construction, Annex 3. But that was allowed. But now 2024, that was allowed in 2009. In 2024, they say, if you also look at Annex 5, that I have made some additional construction which is beyond the permissible limit.
Yeah.
That is what actually they say. One is vertical, the other day you also indicated. As a fact that vertical construction could not have been constructed. But even without recording my submission right now, if the other side says, I'm ready to demolish that part also.
No, the show-cause notice was issued under Annexure 6.
Yes, the show-cause notice, if you are saying there has been no inquiry, no measurement in presence of the party. That is one of the ground I have taken. The notice has been issued, I have given a reply.
But how then it was mentioned that this is the square foot?
Sir, exactly. That is my grievance. Without measuring in my presence, they could arrive at such conclusion. So that is exactly
that notice does not
indicate anything.
In your presence this was done.
No, nothing has been indicated. If you also look at that notice itself.
Where is that notice?
So kindly look at
Annexure 6,
page 44.
Page 44.
Sorry, 49.
49.
Right, page 49. No.
Yes.
Prior to that. No, what I'm sorry, still sorry. 49 Annexure.
This is the first notice you received, or earlier you have received notice?
Yes. It has been reported that clear violation.
Yeah.
So no report, nothing was there.
Now, after 10/1/2024,
sir,
what happened? You submitted your representation.
The Annexure 8, if your looks at.
Oh, another notice you received.
7 and 8 both.
11
No,
Seven.
7 is the representation.
So 7, if your lordship looks at.
You have prayed for regularization of
Yes.
the additional.
Then I have said that if you find any irregularity, kindly regularize it as per the.
Then another notice you have received under Annexure E.
Yes, my lord.
In that there was a for termination of
Termination. Oh, this is a notice of termination.
notice of termination.
Termination. Then I gave reply Annexure 9.
Then
Last, if you also look at Annexure 10, is the termination letter.
appeal to regularize so. Okay, this was made when on 15/11/24.
Right.
Then what happened?
Then Annexure 9 I have given, page 53, 15/11/24. Then I filed a writ application for lordship. During pendency, actually, 19/2/25, they have issued this at page 55. But there are about
So as it appears, your appeal has been rejected. Regularized so. As per 20 have not certain districts removed.
So regularization is one part. The other part is I have given a calculation, if your lordship looks at as page 54, that I have not constructed beyond it. If your lordship looks at page 54, that I have not crossed the permissible limit of extra construction is alleged. As per information obtained from ITI and RSP, we are entitled to construct 40% of the total area, 3,710 square feet into 40% is 1,484. Excluding existing structure.
There is a provision that you are to prefer appeal before this authority, director in charge.
No, there is no specific provision of appeal, but I have given an appeal to the higher authority.
Because the subject is mentioned that appeal to regularize so.
Yes.
So.
But first thing I say, there is no illegality, no irregularity. But even if they measure it actually, still then I'm ready to give up actually if any violation is there. But there has been no measurement in my presence. And second thing, actually, more than 400 quarters are there. 3 persons have been noticed who are all office bearers of the committee. Committee in the sense, the association. And the general secretary and 2 others.
Mr. Misra, you've stated that in 1993, when you were working as assistant manager, it was allotted. You're still working as assistant manager?
I'm not, I'm the general secretary. At that time, he was.
Now?
No, he retired. They give it on scheme as well retired.
That is not there. No, that was given to you when you were working.
Yes. That was,
In the meanwhile, you have retired.
2003, actually, the scheme came into force.
1993, you were given.
As per the scheme, 2009, they gave a tripartite agreement basis. They gave to 400 persons.
Okay.
And all have constructed. Only 3 persons have been noticed. But 2 others have already obtained stay. Right?
No, but 2009, it says your age is 51 years.
2009?
You are saying tripartite agreement?
Yes. Annexure 2.
You were 59 years then.
Annexure 2. It was 33 years. Interestingly, they have issued another circular notice that anybody who has taken for 33 years, as per the government direction, it can also be extended for 99 years.
First was allotted, thereafter lease. Okay. 1993 was the initial allotment.
Yes.
Thereafter.
What is that scheme for suppose you have constructed something unauthorized?
Annexure 3, Annexure 3. The permission that was granted.
Annexure 3 is the permission.
Yes.
Not the scheme.
No, scheme I don't have.
The scheme, something you had given, we were asking whether this is applicable or a new scheme has come up thereafter.
Scheme actually, that is RSP, it is applicable, but that was, you also indicated, there was construction made prior to 2009. But what I beg to somebody for lordship is that, but if they are regularizing those irregularities, they can regularize.
45, it says something about regularization.
Yes.
But there must be some time period within which
time period is given in the scheme. If lordship looks at, I have indicated that. Kindly check up at page 46. Page 46, the procedure. The date of circular 1st September 2008. Then last date of application, accepting after 30th September. So practically, this is not squarely applicable to my case. I just beg to submit for them that if you are regularized previously, kindly do it also here.
Page
And they have
46,
done it in many cases.
46 your writ petition has 16 pages only. 46 का बोल रहे amendment ही जी पर
And I'm entitled to
Yeah,
40%.
मेरा पर 16 पेज अच्छी गल
Good.
writ petition में
No, no.
46 is part of
Consolidated
an
writ petition. Annexure would have na.
अच्छा अच्छा
Consolidated
okay
writ
हाँ
petition
मिला
1 to 17.
got it
Annexure.
कितने पहले page
Page number 46.
copy of the letter अच्छा
तादर अच्छी बड़े heading अच्छी. Tetrik के बे.
हाँ found it
regarding the scheme and date there.
your sale for regulation.
What have you pointed out in your appeal? That appeal of which is a annexure 9.
Annexure 9, if you are kindly turn to page 50.
It is regularized to the extension of modification of my house.
Right.
Quarter number C by 56, sector 2.
Again.
So you have stated that you have not crossed the permissible limit.
Yes, we have not crossed the permissible limit. In fact, that is correct because I have given specification in page page 54. I have given the specific area within which I have done it permissible limit. And I am ready to give up that vertical part if so required.
Means the unauthorized things you are willing to demolish. Give up means demolish.
So I am ready to give up if the
Give up
necessary.
means what?
Yes. The vertical construction.
Vertical portion.
Yes. But that is prohibited.
No, give up means what? You have to demolish carefully, otherwise it damage the other structure.
And if they will demolish, then obviously the cost will be imposed on you.
The cost will be done, it might damage your structure also.
Since it has not been done, no measurement in my presence, if they really feel that it is done, it is there.
Who is to appear for this opposite party?
So the sale authority.
Steel plan and the steel authority are the contesting party.
No, you
I'll indicate.
According to the state and collector, the collector doesn't have any stand.
No, we are.
So the 8 assistant manager land OP number 8.
OP number 4 would be the 4 and 5.
4, 5 and 8 actually.
4 to 8 would be the contesting.
4 to 8 notice to be.
4 to 8.
And so far 1 to 3 is concerned, you will take care of it.
It is not involved.
Of course, the main grievance is against.
So the land belongs to state. That is why they have been.
But thereafter, that is given to steel authority. In turn, we are given to RSP, and RSP is given to the petition.
Or Mr. S.P. Mishra, and senior advocate for the petitioner. Since the petition has been filed by the petitioner Gopinath Patnaik, challenging the notice dated 14/9/2024 issued by Senior Manager Land Town Service Department, Steel Authority of India Limited, opposite party number 4, wherein the petitioner was asked to remove the unauthorized construction made in violation of the sub-lease condition in a period of 3 months from the date of receipt of the notice and to report compliance, failing which on expiry of 3 months period, Messrs. Sales, Proud Tree Plant shall terminate the sublease and re-enter the premises, and the petitioner has to hand over the vacant position of the premises to Messrs. Sales, Proud Tree Plant by depositing the bill as accrued towards rent, service charges, electricity, water charges, etc. In further prayer, add prayer portion.
Sir, Annexure 10 challenge.
Further prayer has been made challenging the later dated 19/2/2025, issued by Assistant Manager, Land Town Services Department. His opposite party number, Assistant Manager.
Yes, madam. 8 was it?
Opposite
Eight.
party number 8. In which, while rejecting the appeal preferred by the petitioner on 15/11/2024 to regularize the extension made in the quarters, terminated the sublease agreement with immediate effect and advising the petitioner to hand over the vacant position of the premises within 7 days, failing which action shall be initiated for taking over the position of the premises under due process of law. With a further direction, deposit the outstanding dues in respect of the leasehold premises, failing which action shall be taken for recovery of the same. So, para Mr. Refer to Annexure 6, which is the notice dated 10/1/2024, issued by the Senior Manager, bracketry PS
Copy number 4.
from opposite party number 4, wherein it is mentioned that it has been reported that there has been clear violation of the terms and conditions of the sublease. The contention of Mr. Mishra is that this, though it is stated that some irregularities have been made, but no measurement was made in presence of the petitioner. It is further argued that even though an appeal was presented before the director in charge, Sale RSP, by Annexure 9, taking several grounds, but in a cryptic manner, the order was passed under Annexure 10, rejecting the appeal, and the points which has been raised by the petitioner under Annexure 9 has not been addressed to while rejecting the appeal. The Land Council for the petitioner submits that there are various houses where such unauthorized constructions have been made and those have been regularized, but the authorities have adopted pick and choose method in the case of the petitioner, as is one of the office he was holding any post or
General Secretary.
is the General Secretary of
The association.
the association
After retirement also you can hold the
The
position.
Retired Employees Association.
Oh, retired.
of the Retired Employees Association. He further submits that the petitioner is ready and willing to your submission. You at your own cost you can demolish the terminal structure.
Your Lordship may not indicate that. I confess to your Lordship, let them appear and say if they feel that.
Okay. All right. Issue notice on the question of admission, and the petitioner is has got that lease since 1993, while he was working as assistant manager ERW Pipe Plant E in the Cell Rao Steel Plant. Stop. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice on behalf of opposite party number 1 to 3. Extra copies of the writ petition be served on the land counsel for the state so far as opposite parties number 4 to 8 are concerned. Speed post requisites proof of delivery shall be filed within a week. Fixing a date, returnable date, and matter be listed after 4 weeks. Counter, if any, to the writ petition be filed. In the meantime, serving copy on the land counsel for the petitioners. What is your interim application?
So 3890, IA 3890.
IA number 3890 of 2025 is an application for
Staying operation of
notice dated
19
to 2025 issued by opposite party number 8 until further orders. There shall be stay of operation of the notice under annexure 10. Yeah.
But one thing, but you should indicate he was the retired, General Secretary, RSP House Owners Welfare Society. I have indicated in page 11.
Page 11, the paragraph 20.
Paragraph 20, middle portion.
Number 20, two line.
So, in fact, he is presently acting as General Secretary, RSP Housing
General Secretary, RSP
Owners Welfare Society. Great.
And it live streaming critically opposite.
Item 2.
The item 2, the Parawaj committee received based on time to file counter.
All right, land counsel for the petitioner is present. Land counsel for the state submits that he has received the Parawaj comment and maybe given till time to file the counter affidavit. Is this matter in favor of your
कितने दरकार?
3 weeks total?
Had you been asked to get Parawaj comments?
We
It had only been adjourned at the instance of the petitioner.
Instruction allowed Parawaj committee visit because that she was claiming for some benefits. But
So let her place her case.
Yes. My lord, I am challenging Annexure 8. The orders passed by the collector in rejecting my petition for extension of rehabilitation benefit in my favor. My lord, the son and the mother are petitioner before your lordship. The entire land at Galopada Murja was acquired for establishment of the Runta mines. But they have not been extended the benefit of rehabilitation in spite of their approach. And your lordship may kindly turn to pay Annexure 6. Annexure 6, page 28. The relevant portion.
You are challenging annexure 8.
I am challenging Annexure 8 because my prayer for extension of the benefit has been rejected by the collector. And my submission before your lordship may kindly turn to page 28. Page 28, list of displaced person under various categories. One, homestead and all land. My lord, my name is under item number 12, serial number 12.
Yes.
Serial number 12, S.K.Sahoo, the husband of the petition number 1. So I am entitled to my case before your lordship is that I am entitled to get the all benefits, rehabilitation benefit as is being extended to others.
Petition. This writ petition has been filed by the petitioners Contempt and Circumstantial, challenging the order dated 26.
29.8 and sorry, my lord.
No, you are challenging Annexure 8.
Annexure 8 that has been replaced because earlier Annexure 8 I have
27, 2022.
Yes.
26/7/2022 passed by the collector Dhinkana, present the opposite party number 2 in
Page 49, they are
Yes. In rejecting the prayer.
Yes.
you submitted a representation or what?
Yes, I have submitted a
Submitted
representation.
and rejecting the representation and holding that the petitioner has received all requisite benefits that are fairly compensation as per the government policy. And the petitioner has failed to produce any concrete evidence to substantiate or claim as a displaced family. The land counsel for the petitioner referred to जोटा आपण refer करते
Annexure 6.
uh,
Sorry, my lord. Annexure, page 28, Annexure 6. Yes, page 28.
refer to Annexure 6, where the list of displaced persons under various categories have been reflected, and the name of the petitioner finds place at serial number 12.
12.
The Land Council also drew the attention of this court to the
Some problem.
um,
As per the index, what is Annexure 8?
Annexure 8.
हाँ,
Annexure 8.
मैं तो voice ला correction
my
कर
lord, subsequently I have filed because that
So
that
that-
was
No, you filed
the correct, my lord.
correct order or correct index?
Correct order along with the index.
next of High Court chamber.
ऐसे index टा देबे नहीं ये कौन interruption?
The index actually replace करवा रहा था
हाँ,
सेटा भूल क्वेश्चन है जहां फाइल है ना
बाकी तो जल्दी बताओ. Memo along with Annexure 8 is filed. So Annexure 8 all get index ओटे दे जल्दी पछाड़.
it's fine that index
Index टा पछाड़ दे जल्दी हो. Memo flag X ता तोड़े index. अब Annexure 8 टा तो दे जल्दी ठीक है. Annexure 8 there was no problem. Only problem with the index.
No, my lord. Index as well as Annexure 8 both have been replaced.
Annexure 8
Representation.
Representation was earlier.
Representation नहीं थे लेकिन
representation,
नहीं
but
नहीं नहीं हमरो ये अनुसार Annexure 8 ठीक अछि in the writ petition only index टा ଟିକେ match हो नहीं हो.
the order टा तमने ही वो Annexure 9 ही जो
नहीं again Annexure 8
Representation 9 it seems.
Annexure 8 हबो.
आपण जोटा वर्तमान फाइल कले
Again, that is Annexure 8. Earlier representation which was filed that was in my lord inadvertently tagged.
आपण जो 27/2014 रे
Again,
जो इंडेक्स का फाइल करछथि
ଆଜ୍ଞା
ଏଟା ଲାଷ୍ଟ ଆଡକୁ ଅଛି ଦେଖି ପୁରା ଲାଷ୍ଟ 27/10/2024 ରେ
28/11/2024 ମୁଁ ଫାଇଲ କରିଛି ମୋ ପାଖରେ।
ଫାଇଲ କରିଛନ୍ତି 28/11
ଆଜ୍ଞା 28/11 ମୋ
ଦେଇଛନ୍ତି,
ପାଖରେ କପି
ମିଳିଲା।
ଅଛି।
କରୁଛି
ଉପରେ ଅଛି, ଠିକ ଅଛି, ଅଫିସ ଠିକ ଅଛି, ମୁଁ ଭୁଲଟା ଫିଟଉଥିଲି। ପେଜ 16 ରେ ଅଛି ଇଣ୍ଡେକ୍ସ ଟା। ହଁ, ନ୍ୟୁ ଇଣ୍ଡେକ୍ସ ଟା ଅଛି, ସେଇ ଅନୁସାରେ ଠିକ ଅଛି। ନୂଆ ଇଣ୍ଡେକ୍ସ ଟା ସେ ଠିକ ଜାଗାରେ
ହଁ
ଦେଇଛନ୍ତି,
ଠିକ ଅଛି
ଫିଟେଇଲା ବେଳେ ଭୁଲରେ ଫିଟିଗଲା।
ଓକେ ଆପଣ ଦେଖେଇ
ନା ନାଇଁ, ଦ ପ୍ରୋବ୍ଲେମ ଇଜ व्हाट दे हैव डन। ଏଟା କିଏ କରନ୍ତି ଆଇ ଡୋଣ୍ଟ नो। ଇଣ୍ଡେକ୍ସ ଠିକ ଜାଗାରେ ରଖିଲେ ଯୋଉ ବୁକ୍ ମାର୍କିଂ କରିଛନ୍ତି, ବୁକ୍ ମାର୍କିଂ ଟା କରେକ୍ସନ କରିନାହାନ୍ତି, ଖାଲି ଗୋଟେ ଲାଇନ ଲେଖିଦେଲେ ଯେ be corrected according to the index, ଠିକ ହେଇଯାଉ, ନହେଲେ ପରେ ପୁଣି କନଫ୍ୟୁଜନ ହବ।
to the 2006 policy and submitted that the opposite party number 2 was
इंडेक्स ଟା करेक्ट है, तो खाली
no
आनेक्सर
in rejecting the representation filed by the
अपन
petitioners. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite parties number 1 to 3. So far as opposite party number 4 is concerned, requisites for issuance of notice by speed post with proof of delivery shall be filed within a week.
item 2
Therefore, Land Council for the state submits that he has already received para-wise comment and he will file the counter affidavit within 3 weeks. You are good at it. After the date fixed for 4 weeks for it, counter affidavit be filed by the opposite party in the
खाली registration correct the as per the new index which has been filed.
The bookmarks of the digital records shall be corrected as per the new index which was filed on new index dated
28/11
filed on
28/11
2011-2020.
Hello?
Yes.
obliged.
केबे वाला
4 weeks पर कौन जो डेट को ले पकड़ेगा 21 पर April 22 22nd April 2025.
obliged.
Item 3.
April 1 week after, I have applied the certified copy of Annexure 1 that was not received. That is 1 week after.
Just
सबूड़ा
Huh.
this is that case where notice was issued, everything was there, suddenly said जे
No,
बहुत
no.
देरी हेलानी, dispose कर देले case in absence of
Yes,
everybody, सेटा तो
No notice was issued.
The notice was
Confirming the-
directed to give the certified
Confirming
copy
the
to entire
LA
location.
order.
you had asked for enhancement, से किछि न करी कर देले जे आरटा
नहीं नहीं नोटिस न देगी ताको
नोटिस काग ଦେଇଥାନ୍ତେ
ଆମକୁ ପାଟିକି
କଣ पर enhancement ମାଗିଛନ୍ତି
ସେମାନେ ନିଜେ ଫାଇଲ କରିଥିଲେ
ଆପଣ କଣ
they-
file କଲେ?
as per section 20 your lordship may see where when the LA court received the objection he has to issue notice to the parties.
Parties mean to the objector or to the other party?
Objector as well as the interested party.
Section 20
of the LA.
ଇନଫାକ୍ଟ ଏଥିରେ ପେଟିସନ ସବୁଠି appear କରୁଥିଲା ମଝିରେ appear କଲାନି ଆଉ
ଜମା ଜମା ମତେ ନୋଟିସ ଜମା ଆସିନି ମୁଁ ସେଇଥିପାଇଁ ଦେଖିବା ପାଇଁ
no, all right, it's all right. We want to know what is the proper procedure. Even if you have missed, we can consider, but whether you have to be noticed, no, भूल है जो order.
No, madam. As per section 20,
How?
because the that slip which they have given district court Jagatsinghpur सबू के डेट रे पेज 11 12
Date
10
होउछि
11
तो, हाँ.
12 देखोछि awaiting SR
Yes, sir.
तापरे SR रो कोन अल्टीमेटली हैला किछि नै हठात dispose of ଦେଖଉଛି 6/2/2023
କିଛିଟା କେସେସ୍ ରେ ଅର୍ଡର ସିଟ୍ ଅଛି and SR is a କେସ୍ ଟା ଫାଇଲ କଲେ SR ତ ସେମାନେ
हाँ ठीक
କରିବେ
ଅଛି, you are right.
हाँ
20 says applicant को भी notice हो.
notice हବ ଯେଥିପାଇଁ
ठीक ଅଛି, ଠିକ ଅଛି, ठीक ଅଛି, ठीक
in
ଅଛି.
some cases
The learned
you lost
counsel for the petitioner submits that the certified copy of Annexure 1 has already been applied for and some further time is required to produce the same.
when we capture
ନା ସାରିଦବା. One thing ବିନା notice କରୁଛନ୍ତି.
Detail ଲେଖା ହେଇଛି ସବୁ ଇଏରେ ଆମେ
Finishing with the file बोले जानते हैं केस में चल पढ़ी रहे सर्टिफिकेट करते हैं, that is the case. Notice है ही नहीं. I think some matters were disposed of.
ହଁ ମାଇଲା
Yes.
ସବୁ ଡିସ୍ପୋଜ ହେଇଛି, ଏଇଟା କିନ୍ତୁ ମୁଁ କପିଟା ଆଣିନି ତ ସେଥିପାଇଁ ମାଇଲଟ ମାଗିଥିଲେ, ମୁଁ ଆପ୍ଲାଏ କରିଦେଇଛି, ସେ ଆସିଯିବ ଏଇ ଭିତରେ ଆଜି।
Can we take it
You
up?
want to
Then we'll take up on second.
Second or ninth?
for
ଆମେ ସେ ଏକା ଡେ କୁ ରଖୁଛୁ ତ ସୁବିଧା ହବ ବୋଲି, so
ହଁ
ଆପଣ
ସେ ଚାରି
ତ 2 କୁ ରଖିବା ନା 9 କୁ
ହଁ,
ରଖିବା?
2 କୁ
ଆଜି ମଙ୍ଗଳବାର ତ
ହଁ, 2
କେନା ନାଇଁ, ତା ଆଗରୁ 4 ଦିନ ଛୁଟି ଅଛି,
ହଁ 2 କିଲୋ
ଆଣିପାରିବେ ତ?
ହଁ
ହଉ.
There's this matter on second. Yes.
Item 4.
May I please? The yellow week ଅଛି ତାଦେହରେ ଗୁଡାଏ ମ୍ୟାଟର ଅଛି ତ ସେଗୁଡା ସବୁ ତ ଅଛି। Yes.
ସେ ନମ୍ବର ଗୁଡା ପକେଇଦେବେ ଆଉ.
Item 4.
Here, my lords, despite the order passed by the civil court, my lords, I have not yet received the compensation amount. Therefore, I am before your lordship. Also, government has taken time to take instruction.
Judgment was passed by the senior civil judge Bhubaneswar.
My lords.
So that he is entitled to get the compensation amount. Order was in his favor, but no amount has been disbursed.
We've given you 1 month time.
They deposited in civil deposit. So we have issued letter. I pray for 1 week after so that complete. It was deposited for the civil.
No, that is all right. But you have to give instructions so that order can be passed.
1 week after.
You got instructions or not?
And instruction 50 ଯାଇଛି instruction.
ନାଇଁ ନାଇଁ ଆଉ ତ କେମିତି
ଆଉ
କହୁଛନ୍ତି?
ସିଭିଲ ଡିପୋଜିଟ କୋଉ ବେସିସ ରେ କହୁଛନ୍ତି?
Deposit ହେଇଥିଲା ତ ସେଟା ନିଜେ
ନାଇଁ, ନାଇଁ।
ଥିବ ନାହିଁ.
We
As per instructions you
dispose
give.
of the matter. Once we record your submission, we can dispose of that. The amount is lying there.
1 week after.
The amount is there, your lordship may see in the judgment itself. Amount is lying since 2014, my lords.
କିଏ ଫାଇଲ କରିଥିବ some problem, let him get instructions.
The
କଣ ଥିବ?
counsel
କାଇଁ
for
ଦଉନାହାନ୍ତି ଏତେ ଦିନ ହେଲାଣି?
the
Civil court deposit ହେଇକି ରହିଛି, case dispose of ହେଇଗଲାଣି. Despite that, ଆମକୁ ଦଉନା.
Exactly, so it must be some reason.
Instruction.
the land council for the state takes some more time to obtain instruction as per the order dated 11/2/2025.
When did you issue letter?
One letter, first letter was issued on 12 February and second thereafter on 28 February.
It is submitted that 2 letters have been issued to the concerned authority for obtaining the instruction. However, no response has been received.
କାହାକୁ ମାଗୁଛନ୍ତି?
Land acquisition.
Opposite party number କହିଦଉନାହାନ୍ତି ଲେଖିଦେବା ଏଟା
Collector का special लेंगे, collector no special लेंगे.
No, so if you don't send to the right person, instructions won't come.
नहीं collector we have received collector and register seal report. The deposit is for the register seal.
issued letters to ଲେଖିଦିଅନ୍ତୁ opposite party number 1 and 2 for that. And matter to be listed, you would say 1 week after.
ଦି ସପ୍ତାହ?
The
9 ତାରିଖ 8 ତାରିଖ
8th of April.
ଲାଷ୍ଟ ଚାନ୍ସ ଏଟା
ଆଜ୍ଞା।
ନ ଲେଖିଲେ ବି ପ୍ଲିଜ ରିମାଇଣ୍ଡ ଅସ୍ ମିଷ୍ଟର ପଣ୍ଡା।
Yes. For the hard Mr. Anam Charan Pandal and counsel for the petition. Yes.
Item 5.
Let's say pray for a pastor.
Item 6.
directed to the Union Council to obtain instruction from the concerned authority in connection with Revenue Appeal Number 65/1971, which has been pending before the sub-collector Panpos, Rampur.
25/3/2025 की the date is posted.
Posted to
25/3/2025.
Obliging impediment नहीं से जनरल disposal पर final hearing करेंगे disposal
for what?
hearing
For hearing?
hearing
Okay.
fixing
और
consistent for next
hearing and
hearing
Taking further course of action.
hearing नहीं तो
हाँ, say it.
that
Further
is
input. No.
let you know as per the order dated 4/3 अच्छा एक line चलेगी this petition has been filed by the petitioner Prakash Agrawal seeking for a direction to the opposite party number 3 sub-collector Panpur Rauthala for concluding the proceeding in revenue appeal number 65 of 1971 within a stipulated period, which was filed in 1971 and where the petitioner has been subsequently added as a party. By order dated 4/3/2025, we asked the Land Council for the state to obtain the status of the revenue appeal number 65 of 1971. Today, the Land Council for the state has produced the written instruction received. Written instruction dated 12/3/2025 received from Sub-Collector Panpur, which indicates that notices have been issued to the parties concerned in connection with revenue appeal number 65 of 1971, fixing 25/3/2025 for necessary hearing and taking further course of action in the said appeal. The written instruction is taken on record. Such written, in view of such written instruction received, we expect the sub-collector Panpos, that is opposite party number 3, to expedite the hearing of the revenue appeal number 65 1971. Time concluded within a period of 3 months.
Time setting content expeditiously without giving unnecessary adjournments or
expeditiously without granting unnecessary adjournments to the parties. Yes, the Land Council for the petitioner shall produce the certified copy of this order before the opposite party number 3 to proceed with the matter.
no legal impediment.
If there is no legal impediment, expeditiously, one said, if there is no order. Not allocating.
Mr. Behra, you Mr. Behra.
Niranjan Behra.
Item 7.
After section 13 of the Contempt settlement action, madam, kindly go through page number 11. There is illegal document note of Balaram Chaudhary, who has chosen his reason the above. Petitioner being his successor succeeded to the property and are in the possession other today also.
No.
If you directly have to go.
You have filed this application, Umakant Chaudhary.
Umakant Chaudhary, the petitioner.
You have filed this application to settle the land
Yes.
in your favor under the OGLS Act.
under the OGLS.
So, have you approved the authority concerned?
But
That
Where is
by
your application?
changing the kisam puଣି ଆମେ କଣ ହାଇକୋର୍ଟ ଚେଞ୍ଜ କରିବ kisam?
Have you approved the concerned authority?
Annexure 2, Annexure 2, my lord.
Annexure 2
2
is your application.
is
When you submitted that application?
application was submitted on 9th January 24.
Yes, thereafter, what has happened? You submitted another representation.
He requested many times, but everything went pell-mell. After that, he represented to the collector on 28th June last 24th.
You earlier approached this court or what? Or what is this annexure
Similar.
4 similar order?
Annexure 4 is a similar order. Covered matter is
Without expressing any moving dispose the so and so, directing so and so to take a decision on the representation of the annexure. ଏଠି ଏ application ଉପରେ କିଛି proceed କରୁନାହାନ୍ତି ଆପଣ କହୁଛନ୍ତି?
Yes, that is pending now. Prayer for disposal of the annexure 2 by the
that dispose of representation
ନାଇଁ ନାଇଁ ସେ
application କରିଦବା ହଁ ଏଇଟା ହେଇକି dispose of
application ଉପରେ
representation
କିଛି application ଉପରେ କିଛି ନେଲେନି ବୋଲି ଗୋଟେ representation ଦେଇଛି। ହଁ
application ଟା
ଦେଖନ୍ତୁ,
legal impediment
this
take a decision on it.
writ petition has been filed by the petitioner Umakanto Chaudhary for a direction to the you submitted this application before
the opposite
party to dispose of the inter alia dispose of the application for settlement of land in form number 1 by the opposite party number 3 in accordance with law. The land council for the petitioner submitted that under the OGLS Act 1962, the petitioner, you submitted that application.
My lord.
Umakanto Chaudhary, the petitioner, submitted the application under Annexure 2 on 9/1/2024. And since no action was taken on such application, a representation was also filed on 28/6/2024.
The village belongs to village Raipur and claiming for the Noladia Panda.
Copy paste କରିକି ଭୁଲ କରିଛନ୍ତି dismiss ହବ ତା ଦେହରେ
Reject କରିଦିଅନ୍ତୁ କିଛି ନାହିଁ କାଇଁ ପକେଇ ରଖିଛନ୍ତି କାଇଁ representation under Annexure 3, but nothing, no fruitful result has come. Considering the limited nature of grievance of the petitioner and without expressing any opinion on the merits of the case or the application which has been submitted under Annexure 2, we direct the opposite party number 3 to take a decision on Annexure 2 expeditiously. Expeditiously. And communicate the result thereof to the petitioner within 2 weeks of the taking the decision. The petitioners have produced the certified copy of this order before the opposite party number 3 to proceed with the matter. Yes.
time ଟେ ଦବା
313 and result thereof shall be communicated within 2 weeks of taking the decision. Yes. And we will produce the certified copy of the order. All right. Yes. Similar similar matter in that item 7, 8.
8 similar.
8 is that is a joint application.
Oh,
Joint application
Kata
also
Kota Mauja and a partial equal.
The claim କରୁଛନ୍ତି as per the page 11
petitioner ସଉଛନ୍ତି ତ 5 ଜଣ
5 ଜଣ
ସେ application କିଏ ଦେଇଥିଲେ
ସେ 5 ଜଣ
5 ଜଣ ଯାକ ଦେଇଥିଲେ କଣ ଅସୁବିଧା
ଠିକ ଅଛି ଗୋଟେ ଫ୍ୟାମିଲିର ଦେଇଛନ୍ତି
ଫ୍ୟାମିଲି ଦେଇଛନ୍ତି
ନହେଲେ ଆପଣ ଯୋଉ ୱେଷ୍ଟଲ୍ୟାଣ୍ଡ କି ଦଉଛନ୍ତି ଲିଜ୍ ହୋଲ ଫ୍ୟାମିଲିକୁ ସମସ୍ତଙ୍କୁ 5 ଏକର 5 ଏକର ଇଏ ଠିକ କରିଛନ୍ତି ଏକା ସାଙ୍ଗେ ଦେଇଛନ୍ତି
ସେମିତି କରୁଛନ୍ତି ନା yes
ଖାଲି କଷ୍ଟ ଟାଇଟଲ ସମସ୍ତଙ୍କ ନାଁ ଲେଖିଦେବେ
ପିଟିସନର୍ସ ମାନଙ୍କର ନାଁ ଲେଖିବେ ଏଇ ଯୋଉ 5 ଜଣ ପିଟିସନ ଲେଖିଛନ୍ତି ତାଙ୍କ ନାଁ yes disposal
Item 9.
Item 9, my lords. My lords, Mr. Mishra is appearing on caveat. I'm for the petitioner. Caveat a bhul rahe aisi matter hai. But I have already served a copy. This
The party is the same. It was in respect of public hearing.
So I'm just.
So you take back the application. Caveat 8 no hata?
No, this is not the caveat. This is not the writ application for which the caveat was filed.
Caveat, but in respect to the same person, but for a different issue.
Different issue in a different court altogether. That is also
there.
That is also there for hearing today.
all right
So caveat you can use then for that case.
That has already been used. I had filed 6 caveats.
Okay.
2 of them has been tagged there.
My lords, this.
But if your lordship.
But in this there is in this there is no caveat.
There is no caveat. There is no interim application.
All right.
It's a matter for structure compensation.
Yes.
Your lordship, this is also a writ application.
Caveat are wrongly tagged.
The land council for the petitioner at the outset submits that the caveat petition number 209 of 2025 is not connected to this writ petition.
And Mr. Mishra also.
Mr. Mishra also, Mr. Anindya Kumar Mishra and council
does not dispute this.
Doesn't dispute this same. Yes.
Your lordship, this is a writ application pursuant to the directions of the Honorable Supreme Court regarding the claims commission matter. Here, my lords, your lordship may take annexure 2, page 27. I had filed a claims case before the learned commission, praying for a grant of compensation for a structure, a house over my plot. If your lordship sees the order sheet at page 27, the learned commission had called for a report of the inquiry team, and they had given a report that it was an old structure. So the learned commission had made a direction that I should be paid compensation for that particular structure. Your lordship may see the measurement sheet which has been prepared by MCL, which is at page 35 to my brief. If your lordship sees serial number 2, Pakka house with asbestos GI sheet roof, and there is a noting new, which is why they have not granted any compensation under the heading. Despite
this annexure 2, which you are, that is the order dated 7/1/2020.
Yes, my lord.
There, it seems that the claim commission member has asked the MCL to assess the compensation in respect of the structure on the basis of the expert team.
Yes, my lord.
And submit the same to the office of the commission.
Yes, my lord.
After receipt of the same from the MCL, office shall make necessary count. So this has not been carried out.
This is not, no, they have carried out. Your lordship may see the measurement sheet. The claims commission says that I am entitled to structure compensation basing upon the report of the survey team. What MCL does, your lordship may see now page 35 of my brief. Serial number 2. MCL has categorized the structure as new on its own and has not granted me compensation. That is my only case. Other than that, my lords, there are some more ancillary prayers, such as EI and PH has not been granted. I'm also praying for interest on structure compensation. But primarily, my point is, despite orders of the commission and the survey report, MCL has no authority to categorize it as a new structure.
This writ petition has been filed by the petitioner, Sushil Nayak.
Will you accept notice, Mr. Mishra?
If you're not so direct,
No.
otherwise.
With following prayer. Lekhidewa na nahi notice jiwa PowerPoint and
See, कुछ ना instruction नहीं, so if he direct, he will receive.
Unnecessarily.
There's a panel of.
No, that is why we don't want. Issue notes on the question of admission indicating therein that the matter shall be disposed of at which field of permission. Requisites for issuance of land. You are appearing for OP1, Land Council for the state accept notice for the Jonah Pine Oka Pine.
Let's collector ADA.
1, 3, 4, and 5. Accept notice, extra copy of the expedition visa. So far as opposite party number 2 is concerned, requisite will file issuance of notice. Matter be placed so and so. The Land Council for the petitioner referred to Annexure 2, which is the order dated 7/1/2025 by the Crime Commission, where the MCL was directed to assess the compensation in respect of the structure on the basis of the expert team report of the expert team and to submit the same to the office of the commission. The Land Council further submits that erroneously the MCL authorities have held what is a ground nation the old structure building. ସେମାନେ ଆପଣଙ୍କର claim ଟାକୁ reject କଲେ କୋଉଠି କାଇଁ paragraph
In the writ application, Your Lordship,
yes
is,
writ petition
yes, Your Lordship. Your Lordship may see para 11.
para 11.
Para 11.
Referring to the paragraph 11 of the writ petition submitted that the assessment which has been made by the MCL is highly arbitrary and illegal and has been prepared in contravention of RNR 2030. Yes. Date
After 4 weeks, 4 weeks, after 6 weeks, date
29th.
हाँ 29 ही जो अजी जल्दी 18 15th से 4 weeks 29th
29th April 2025. Yes.
Grateful minutes.
Item 10.
Will submit my lord. This petitioner is a scheduled caste person. Belongs to Kolahandi district.
Yes.
Declaration was made by the government and by the authority that his land was acquired. But land acquisition, no provision is complied with. 4, 5, 6, 7, nothing is complied with. But land is, they said, land is acquired.
You have not received any compensation also.
Compensation only given me.
Yes.
That is also a 30, Your Lordship may see, Annexure 3.
that is what
No, compensation. How much compensation you have received?
Compensation received. Compensation was also Annexure 3, Your Lordship may see, Annexure 3.
paragraph 7 you have stated
Notice Annexure 3, page 17.
Yes. So that is in 2006. तो क्षतिपूरण टंका 53,944 टंका धार्य करा जायछि एथिपई आपनकु पूर्वरु मध्य क्षतिपूरण टंका ग्रहण करिया पई नोटिस करा जायथिला आपण से दिन क्षतिपूरण टंका ग्रहण करि नांती किबा तापरे क्षतिपूरण टंका ग्रहण करिया पई भू अर्जन अधिकारी स्वांसु को जणाई नांती तेणु एही नोटिस माध्यम रे जणाई दियो तो टंका अछि
Force was applied that I must accept this.
You did not accept.
paragraph 7 he has
I
stated
accepted
Yes.
because of the fact that it will not be, it will be sent somewhere.
You are dissatisfied that this should not be, it should be on a higher side. That is your case.
no
My case
What
is,
is your case?
my land is not acquired. It is in my possession. But
No.
the provisions of Land Acquisition Act has not been complied with. 442.
No, you have received the compensation amount.
Only compensation received.
You might be in the physical possession, but in pen and paper they have already taken possession and they have already paid compensation to you and you have received the same.
My lord, only by letter possession cannot be taken.
No. You are saying that you are still in physical possession.
Physical possession is necessary.
Right.
They are not accepted. They have not received physical possession.
The moment you have received the
amount only, because of this letter, after that I was forced to receive the loan. The
Why do you say force?
Huh?
You were asked that you till date you have not taken and received.
Why
are you saying force?
You are issued notice, you appear before
notice
the
was
authority.
given that unless you receive this, this will go to that place or that place. I'm a villager, a scheduled caste villager. Your lordship may consider that part also. It's a threatening to me.
No, ଆପଣ ଏଇଟା ଏଇ ନୋଟିସଟା ତ ୟୁଜୁଆଲି ଯାଏ ଆପଣ ଯଦି ଗ୍ରହଣ କରିବେ ତାହେଲେ ଏଇଟା ଖଞ୍ଜଣା ଖାନା କିମ୍ବା କୋର୍ଟରେ ଜମା
କରିଦିଆଯିବ।
ଏଇଟା ହଁ ତ ଆପଣ ଆସିଲେ ରିସିଭ କଲେ 2006 ରେ ରିସିଭ କଲେ
today my lord, the land is with me, but they are utilizing the land otherwise. Otherwise means pipelines, etc., etc. Also the company.
They have
and this is not, my lord. The thing is, this is not acquired for the public purpose. It's for a company. They say land cannot be acquired like this for a public purpose unless it is a public purpose.
Question is, if you are dissatisfied with the quantum, the provision is there where you are to.
But provision is also amended 101. The recent 213 Act, if it is not,
the question is
that can be returned back, the land can be returned back to the person.
No, Mr. Mahanti, we are asking you a pertinent question. In 2006, after receiving the compensation amount, you sat silently, you did not. Now, after 18 years or 19 years, you are coming off and saying that those formalities are not considered. So why will condone those delay or latches?
I sat over the matter because I was buying the land. I was in occupation of the land. Now they have forced me that to leave that land and they have to acquire it. So
have
already acquired.
Your lordship may see.
They want to use it.
Now they are using it by taking gas line or pipeline, whatever it may be.
Your lordship may see it. The annexure 878 7 and 8. 7, 6 and 7. Annexure 5 and 7. After 5 years of occupancy, my land is destroyed like this.
You are appearing for whom?
Annexure
opposite number 4, my lordship. Vedanta.
On party number 4.
Yes, my lord.
Annexure 4. Where is a caveator? Caveator notice is given. I mean,
what is your submission?
My lordship, we need to file counter on this one.
Please solve upon that. My lord, I am in business. I am making business on the plot. They are asking me to vacate the land.
It is their land now.
Vacate the land?
Yes.
Again?
It's taଙ୍କ ଜାଗା ପରା
ତାଙ୍କ ଜାଗା ହେଇଗଲା ଆପଣ ଟଙ୍କା ଦେଇଦେଲେ ସେଟା ତାଙ୍କ ଜାଗା ହେଇଗଲା ତାଙ୍କର ସିଏ ଯାହା କରିବେ ଆପଣ ଟଙ୍କା ନେଇଗଲେ 2006 ରୁ ଚୁପଚାପ ବସିଲେ
because you have utilized the land, it is good. They are not asking you for utilizing the land. They are not asking you for anything. Land is theirs. You are utilizing it. It is good. But they will utilize the land.
ଟଙ୍କା ସିନା ନେଲି କିନ୍ତୁ land ତ ସେ ନେଇନାହାନ୍ତି.
ବର୍ତ୍ତମାନ
they have not accepted the land. They have not occupied the land.
Yeah. heard the Land Council for the petition.
19 years I have been enjoying the land.
The petitioner, Shradanand Naik, has filed this writ petition with a prayer.
Master
for
10 and
direction to the
Annexure 10 and 11-year-olds see that the authorities say that they do not get the notification.
to declare the forceful acquisition of the land as illegal, unconstitutional, and violative of the Land Acquisition Act and rules. And the possession and utilization of the land be declared in favor of the petitioner so that he can use the land according to his choice. It appears from the notice under Annexure 3, which is dated 12/21/2006, issued by the Land Acquisition Collector Kalahandi, that for an amount, a compensation amount of 53,944 was fixed for acquiring the land of the petitioner. And that notice further specifies that earlier notice was issued on 16/11/2005, inviting the petitioner to come and receive the compensation amount, but the petitioner did not turn up. Accordingly, by notice under Annexure 3, the petitioner was asked to appear before the Land Acquisition Collector Kalahandi on 6/1/2006 to receive the compensation amount. Otherwise, the amount would be deposited before the revenue authorities or in the court. Mr. Mohanty, Land Counsel for the petitioner, submitted that the petitioner has received the amount as mentioned under Annexure 3. However, he was in possession of the land and cultivating the same.
Cultivating मध्ये नाही. You have made some brick.
No position.
ନାଇଁ ନାଇଁ ଆପଣ କଣ କରିଛନ୍ତି ଯୋଉ
ମୁଁ ସେଠି ଗୋଟେ
ଏବେ
brick
ଗୋଟେ
ତିଆରି କରୁଛି.
brick ତିଆରି କରି
and utilize the land for the purpose of constructing a brick kiln.
Annexure 8. I'm producing bricks.
Brick kiln. KILN for you. Hello. And recently, the opposite the concerned company कौन एबे कौन कले बेल लिखिचंती एबे से माने कौन करूचंती बेल लिखिचंती आपण
10 and 11 Annexure your lordship may see that I wanted whether the land is notified or not.
नहीं नहीं आपण जो एबे से माने कौन कहउचंती कौन पाइप नेलेनी ना कौन कोरा कहले कोड सेटा लिखिचंती आपण करो
पाइप नेले पाइप लागिची Annexure 8
कोड लिखिचंती अभरमेंट टेकन किसी करचंती रिपिटिशन ले से विषय आपणकर रिपिटिशन में किसी अभरमेंट नहीं से विषय रे however submits that the authorities are now trying to utilize the land. Stop.
Paragraph 11.
And in paragraph 11.
Water pipeline and cable laying. देखिए paragraph.
Acha, they have taken the water pipeline and cable laying work on the land. It is argued by Mr. Mahanti that the provisions of the Land Acquisition Act has not been followed by the authorities while taking possession of the land. We find that there is inordinate delay in approaching this court. Moreover, if the petitioner has received receiving the compensation amount as per notice under Annexure 3 was not satisfied with the quantum, he would not approach the appropriate authority, which has not been done as yet. Since he has received the compensation amount and the authority is now utilizing the land for the purpose of taking water pipeline and cable laying work, there cannot be said to be any illegality committed by them. Accordingly, we find no merits in the writ petition, stands dismissed. Yes.
Lordship may see
The
section 1
the name opposite party number 4. We have not issued notice, not necessary.
Okay.
Yes, next. Or item number 11.
or notice issued.
No, we have dismissed your writ petition.
RS
Item number 11.
counsel.
Next item.
Hmm?
No, dismissed. I have last one. Your Lord- Your
Yes.
Lordship. Your Lordship, the case of the petitioner here is that a few years after her retirement, she came across an official memorandum which was circulated while she was working as a teacher in Kendriya Vidyalaya Sangathan. The case here is that during her joining or during her service period, this official memorandum of converting a person who is under CPF to GPF was never brought to her knowledge.
What
And
was
then-
your prayer? Where is your original application?
No, just one question. So, Kendriya Vidyalaya teachers come directly to the High Court, or
So she had filed a original application before CAT.
okay, where is that?
That is in annexure number 1, page 30.
Okay.
So, what was your prayer? Can we have you annexed that original application?
I have only annexed the order.
No, in the order, the prayer has been
Prayer-
quoted somewhere. What was your prayer before the Central Administrative Tribunal?
The order is a very long one. There was a place. Kindly look at Your Lordship, page 19.
Hmm.
Your Lordship, kindly take a look at page 19.
Please show us the prayer portion, madam.
Page
We want-
19.
Page,
Page 19.
page 19.
19.
Yeah.
The last paragraph where an extract of the prayer is.
Okay, okay. Oh, that was there. So, passing a letter of communication dated 6/9/2019 under annexure A by 6. What is that A by 6?
Your
You see,
Lordship,
that is why it is necessary that you should have filed the original application with the all annexures. We could have directly seen that what is the annexure A by 6, all these things. We were not filing anything.
So is there any way we can know what is that letter dated 6/9/2019 from the documents on record?
no. Kindly give me 1 week time.
Kindly give me 1 week time. I will
All right.
get those documents.
Just ଆଉ ବି କଣ ଥିବ ଦେଖିଦବ ଆଉ କଣ ଦରକାର ଥିବ latest ଗୋଟେ ହେଲେ that we need that ଆଉ
Original application along with
Here
the
was that she
annexure
should be granted the status under the as a pensioner under GPF and not under CPF.
So once you file that original application with all the annexures, we'll able to know that what are you challenging because you have not also annexed those documents in this writ petition.
I will arrange
Right.
those documents.
so if you give your copy of your OA that
I
will
will
contain everything
get it from the council who had previously
yes.
filed, and I will.
So what time you require?
10 days. 10 days should.
You are appearing for
Union of India, opposite party number 1.
give your country number.
Member.
Senior family party by the appearance limit for the Union of India in court today.
Was a counter filed by the Union of India by the Kendriya Vidyalaya.
It's filed. All those documents.
That copy also you give it so that
counter.
during course of argument, the land counsel for the petitioner seeks for an adjournment to file the original application along with the annexures. So also the copy of the counter affidavit filed by the Union of India. Any rejoinder you have filed?
Rejoinder.
So also the rejoinder filed by the petition. Put up this madam. 10 days. Let's wait on that.
3 सप्ताह 2 ही नहीं 9 8 तारीख को
8th of April 2025.
8 April alright.
Applicating the name of the senior panel counsel in the first.
No.
We are just coming with it.
This case I have challenged the order of London Cat at Annexure 1,
Which item?
page 12.
Item 12.
Yes, what have you challenged?
The order of London Cat at Annexure 1, my lord. I had earlier I had approached the London Cat and they refused to give the interim protection I had prayed for. The interim protection in the nature of stay of departmental proceeding because both departmental and criminal case have been instituted on the same charge. But London Cat does not incline to give the protection, saying that the charge sheet in the criminal case has not yet been filed. But the fact is that charge sheet has been
So
filed.
your matter is, as it appears, it is sub judice.
Yes, my lord. It is sub judice.
So why have you come against
against
an interim order?
Yes, ma'am. Because they have denied to state the departmental proceeding.
Why it will be stayed?
And Lord, if it is continued, my lord, I will have to expose my defense before the departmental proceeding.
No. Is there any bar that it is cannot be continued?
I had relied on the decision of this honorable court, wherein this honorable court, in some other cases, have directed to stay the departmental proceeding for a period of 1 year.
In some cases they have directed, some cases also they have refused.
Yes, that is yes.
What happened in that criminal case? Where
criminal case, it is at the stage of production of police paper.
Okay.
And
so charge sheet has been submitted. It is at the stage of supply of police paper to you.
Yes, ma'am.
Okay. So it will take a long time. So that means the witnesses will be summoned, they will be examined, and all these formalities of the trial would be there continue. And since if you will be allowed, you have now been placed under orders of suspension.
No. I'm still working, madam.
Then why the departmental proceeding?
Because my lord, only thing is that if I proceed, they proceed in the departmental proceeding, I have to disclose my defense there.
Yeah.
And it may utilize against me in the.
But the appreciation is totally different in a departmental proceeding and the appreciation which is to be made in that criminal case.
Well, to that extent, my lord.
In fact, that is what the tribunal has stated.
Yes, my lord.
They said in these cases, the allegations are exactly the same. That is why in this it is different and distinct.
On that is the observation of London Cat, my lord.
Yes.
But my lord, at page 44 to this writ petition, I would like to draw my kind attention of my lords to what are the charges against me. Hence, may I be permitted to read, my lord?
No.
Because, my lord, in the CBI case, the charge in the criminal case is identical to the charge of departmental proceeding, and they are relying on a telephonic conversation. And if that conversation can only be proved in the criminal case, my lord, I have neither I have been arrested, nor illegal gratification money has been recovered from me, nor I was in the trap place.
What are the things to be?
But over a telephonic conversation, they have now implicating me in the criminal case as well as in the departmental proceeding.
No, where is that allegation against you?
In the departmental proceeding?
Yes.
My lord, page 44. May I permitted to be read, my lord?
Page 44.
To the writ petition, my lord. It starts with hence an amount of rupees 1,02,211.
Yes, please.
And security deposit of rupees 13,588 from first RA bill amount and an amount of rupees 2 lakh and security deposit of rupees 35,109 from second RA bill amount was withheld. Sri Deepak Kumar, that is the petitioner, executive engineer civil, sought undue advantage from Sri Prasanna Monica through Sri Subhasis Pal AE civil for releasing the withheld amounts. Next para, Sri Prasanna Monica filed a CBI complaint on the demand of bribe by Sri Subhasis Pal AEC bill. During trial proceeding by CBI, the Sri Subhasis Pal was caught with bribe money and he voluntarily accepted that he had accepted the bribe money from Sri Prasanna Monica as per the instruction of Sri Deepak Kumar. Later on, the fact was substantiated by phone call made by Sri Subhasis Pal to Sri Deepak Kumar on the instruction of CBI. So neither money is recovered from me, nor I was in the available in the place where trap has been done. But on the submission of Subhasis Pal, another co-accused, I have been implicated. And That is my submission is that if that telephonic conversation is to be taken into consideration, that is to be decided in the criminal case whether it is my voice or somebody else's voice. But only on these things we have been.
Regarding acceptance and all that, that track was laid. Before that, you made a demand.
No, my lord, I have been transferred to Patna. I was in the charge of Orissa.
Demand.
We are not actually. We are not on the either the what would be the result of the departmental proceeding, what would be the result of the criminal case. We are on a very pertinent thing that whether the departmental proceedings should continue or it would be stalled till the adjudication of the criminal case. That is the short point.
Yes,
because you filed a petition to stall the departmental proceeding that has been torn down by the Central Administrative Tribunal. So the allegation, according to you, in the criminal case as well as the departmental proceeding is same. And your involvement in the case is based on the telephonic communication which you as the have made with the main accused. Let us say you are a co-accused. The main accused is the person who accepted the bribe amount, right? So whatever you are saying that whether it was a genuine phone call or not, the voice taste, all these things, that is to be taken care of. But question is that whether in such a circumstances, the law says that under no circumstances the departmental proceedings should proceed and it should await till the conclusion of
that is not the law, man.
Then
both can run concurrently.
But
another point is, my lord, before soon after I received the memorandum of charges, I made a representation to OP number 2 to stall the departmental proceeding and don't give me take a decision on my representation and allow me to submit my written statement of defense. But instead of taking a decision on my representation, straight away they appointed inquiry officer. So I deprived of my right to submit my written statement of defense.
No, that the order is not that. The order is that only considered that.
That point also I had taken before the learned cat matter. That my representation is still pending before the respondent.
Because if you come to paragraph number 8 of page number 18, there it has been mentioned that the interim relief claimed by the applicant for staying the inquiry in the disciplinary proceeding is hereby rejected. So there is nothing on record that you have also prayed that. What is your application?
Application is that Annex 2 minor, page 19, it starts from page 19 minor.
Page 19.
Interim order, page 35. No inquiry be held in the departmental proceeding dated so and so, so and so. That is the interim order.
Where is the interim application?
35. They not
35. Put a paragraph.
Page 35.
No inquiry be held so and so.
Only prayer.
That's only. That is the only prayer.
That is my not only so far as interim prayer is concerned.
How Juta Chamuchanti, set up the main prayer. How can it be allowed in the interim application?
What I submit, my lord, before taking my representation is at Annex A/6, my lord, wherein I have prayed for to stay the departmental proceeding and
your interim application or interim order you required to stay the departmental inquiry. There was no prayer that that prayer was there in the main original application, which is sub judice before the court. The court has to take a decision whether your averment which you have taken or your submission that these particular documents have not been supplied to you is correct or not. Then the court, if finds it correct, then the court can direct the authorities to supply you the necessary documents.
With regard to documents, I have not made any prayer. My only thing is that my representation at Annex A/6 Yes. It's still pending. They have not taken any decision on my representation.
Main prayer is to set aside order
Prior to that, they
29 months.
appointed inquiry officer. So before an inquiry officer is appointed, I must have been given an opportunity to submit my written statement of defense, which I
That is not there.
specifically read not to coerce me to
We are
file.
sorry that your interim prayer is a very limited prayer,
Yes, ma'am.
and that has been addressed by the learning tribunal in the impugned order dated 26 to 2020.
On the ground that no charge sheet has been filed. The learning tribunal has come to that conclusion. At para 5, they have stated that no charge sheet has been filed. But in fact, the charge sheet has been submitted by that. You may refer to Annex 1, page 15 minor. We find that the charge sheet in tier case is yet to be filed. But Annex advisory, it has been filed by.
Yes, so read that entire paragraph.
Yes. However, the bail order reveals that the applicant has been proceeded within the criminal case for demand and acceptance of bribe, which is in violation of Section 7 of the PC Act. Whereas in the departmental proceeding, the allegation is for violation of departmental rules for withholding of the RA bills of the contractor to get undue advantage.
That's different.
And that undue advantage they have elaborated in the memorandum that so Mr. Pal has said that that undue advantage that accepting bribe money from the contractor.
No, that is a different. Where is the charge sheet copy?
Charge sheet matter that annexure A by 2, page 38 of this repetition. Start with
page 38.
Yes, madam. Of this repetition.
No, in the criminal case you said that charge
sheet. Yes, madam. Criminal case matter. Page
not given, please.
48 madam.
48. So that it indicates that the charge sheet was submitted on 39 2023.
Yes, madam.
Right?
Yes, madam.
But has that weighed in the mind of the court that charge sheet has not been filed? It will take a long time. Have they stated that? Only there's one line stating that charge sheet has not been filed. But the allegations they have stated, what is the allegation?
They came to conclusion that since charge sheet has not.
Where is that? Where is that conclusion?
No. During the course of my lord argument.
No. So they must have stated somewhere.
No. It has not been. Either it is in the order. So the only thing I can say that
part has not influenced the authority or the Central Administrative Tribunal to pass the impugned order. The reason otherwise that the allegation made in the criminal case and the departmental proceeding were same, but case staff but whereas in the present case the allegations are different and distinct in both the proceedings.
But my lord, I made my endeavor to convince the learned that both are same, and in fact both are same. But
no, they have stated that how it is different. The that is for acceptance of the bribe, and the departmental proceeding. The allegation is that for violation of the departmental rules for withholding the RA bills of the contractor to get undue advantage.
Yes, madam.
So that is the.
And that, my lord, if your lordship again, if I permitted at page 44, my lord, in the imputation they have stated that what is that undue advantage. And it's exactly at the charge sheet at page number para 16 to 16.4, page 54, my lord. Same thing has been written. That says Deepak Kumar was working as executive engineer, civil postal service division, Bhubaneswar during 2/6/22 to 14/4/23, and as such, he has a public servant. The second RA bill of complainant, Sri Prasanna Manika, was submitted by Sri Subhasis Pal, AE, to Sri Deepak Kumar, EE, Civil, Postal Civil Division, Bhubaneswar, for passing the payment. After scrutiny of the consent check, the said bill in the complaint was put before the Sri Deepak Kumar, Executive Engineer, Civil, for passing. However, Sri Deepak Kumar, Executive Engineer, had his order dated HEK mentioned on the security scrutiny note of the bill of the complainant that withheld of rupees ethically, and thereby deliberately withheld amount of rupees 2 lakh.
This the state of Rajasthan versus Sri
T Srinivas. ନାଇଁ ବିକେ ମିନା ସେଟା ଗୋଟେ ଅଛି ଆଉ
ନାଇଁ ଯୋଉଟା ରିଲାଏ କରୁଛନ୍ତି ଅଲ୍ଟିମେଟଲି କନକ୍ଲୁଡିଂ ପାରାଗ୍ରାଫ ରେ ରେଫରେନ୍ସ କଣ
ସେଟା ହଉଛି
State of Rajasthan.
केंद्रीय विद्यालय
Just a
संगठन
minute. State of Rajasthan लिखा है जी
पेज गोटे देना
versus Sri खल लिखा है जी पार्टी भी ना लिखा है नहीं जो reference दिया है नहीं citation.
गोटे पैराग्राफ टा मिसिंग अछि कि
नहीं से गोटे
बिकॉज़
पेज
पैराग्राफ 6 पर पैराग्राफ 8 आछि
ना सेटा से पेज टा रिपीट ही
कोठी
से ऑर्डर ता फ्री कॉपी रे सेटा
नहीं रिपीट है जे पैराग्राफ 7 के
5 6
पैराग्राफ 7 टा रिपीट है नहीं आपण रॉन्ग पेज मार्किंग करचंती पेज 16 टा दे देचंती पूर्व रे
page para 7 is at page 16 in this form
so पेज 16 टा आगो दे सॉरी जो पेज टा आगो दे देचंती
नहीं Lordship may refer to page 15 of my read petition they are
आगो दे देचंती पैराग्राफ 7
chronologically
is coming before paragraph 6 so
सेटा से order to my lord that order was typed in that way my lord by the learned pen
no
at page 15 my lord
no
Lordship may
State of Rajasthan versus BK Meena से पेज टा आगे दे देचंती
BK Meena
कौन देखी कौन दो
नहीं कि आगे देखो पेज 15 टा
देखी कहूँ से कंटिन्यूअस होची से आरो पेज टा जोटा आगे दे देचन सेटा परे रहले ठीक हबो नले वन पेज इज मिसिंग आपण सीक्वेंस टा भूल दे देचन
1 2 3 4 5 6
2 by 4 पेज टा दे देचंती परे 3 by 4 टा आगे दे देचंती देखो जंती तळे देखंतु पेज नंबर अछि
जो पेज टा सु 15 रे देइचंती सेही पेज टा को आउट रे देइचंती 17 रे
it मतलब I may be
सेट पे कंफ्यूजन होची
but in that way free copy was supplied
हे परिबो नै चारटा पेज अछि टोटल आपण एठी पांचटा पेज करचंती हे जे दिस माने मिस्टेक
What is the latest decision? This is a decision of 1997 Supreme Court 1-3, which has been relied upon by the learned tribunal.
yes ma'am.
So, what is the latest decision?
मतलब only thing that केंद्रीय विद्यालय संगठन केस in केंद्रीय विद्यालय संगठन केस
आपन को कौन पचरा
latest my lord I would my lord my submission is that the order of this honorable court single bench has passed an order
what is the decision we are asking you that this principle which has been laid down in the 1997 Supreme Court has the Honorable Supreme Court has taken any other view after 1997 whether this decision has been
that is there is no order supporting my argument as on date my lord but only on I am relying on the decision of this honorable court taking the decision of M. Paul Anthony this honorable court has stayed the departmental proceeding for a period of 1 year my lord which I have annexed my lord and it has also been annexed before the learned cat Lordship may refer to page number 99 my lord
refer to High Court or the Supreme Court order
no
there are 3 single bench order of this honorable court my lord where departmental proceeding has been stayed as it is instituted on the same
no, this Supreme Court decision is there though.
And there also they have relied on the decision of the M. Paul Anthony and another old case my lord
they have relied or referred rely हेले तो दे न थांदे
1997 Supreme Court page 13 yes put some research assistant take down this decision State of Rajasthan versus BK Meena AR 1997 Supreme Court 1-3 at a subsequent decision the latest decision court rely and a principle they that even if a departmental proceeding and criminal trial is based on similar facts, the departmental proceeding should not be stayed. A decision
after 1997, there is a decision in 99, my lord, which this honorable court has taken into consideration. M. Paul Anthony.
We'll take up this matter tomorrow. Get prepared.
Yes.
So many decisions are coming in the latest. Search for Manu Patra or SEC online. So many decisions are there. You are
पत्र काढी देबे कि ना कोन पेज एपट सपट हे जो पेज टा दी थरा दे दे कंफ्यूजन कर दे आगे पछे जाଉଛି
You follow us? 1997 ମସିହାର ଡିସିସନ 28 ବର୍ଷ ଆ ଭିତରେ ପାସ୍ କରିଗଲାଣି ହେଲା ବହୁତ ଲାଟେଷ୍ଟ ଡିସିସନ ଆସିଛି କଣ ପ୍ରିନ୍ସିପଲ ଅଛି ତାକୁ ଖୋଜନ୍ତୁ ଆଜି ରାତିରେ we'll take up this matter tomorrow ହେଲା put up this matter tomorrow.
Item 13.
Item 12, Malad is keeping tomorrow.
Yes, sir. Mr. Pari, please assist us and find out the latest decision on this one. That even the same fact also, the departmental proceeding can continue and merely pendency of the criminal case is not a ground to stall the departmental proceeding.
Simultaneously, it can be pushed. Yes.
Find out the decision, we'll take up this matter tomorrow. Yes.
Fine.
And Mr. Pari and
Miss present होता है well present और note करने पढ़ी with Miss नाडा बुल्जेज. What is madam's name?
Sulojana Patra.
हाँ सुलोचना पत्र.
present is not present. Yeah.
You filed or you'll file? खाली is present खाली कोई दे.
Present person. खाली appearance में file कर. Yes.
Yeah.
May I please? Here, Madam, challenging the order of transfer dated 14/11/2024 in Annexure 7, page 32. Madam. The petitioner first approached the authority in Annexure 9 representation on the same day, Madam, and in absence of any response, Madam, approached the tribunal. The impugned order of the tribunal, Madam, is Annexure 11, page 50. It starts from page 50. Let me just show to your lordship Annexure 7, page 32.
No, transfer matter. What is the ground? Why will?
And you stayed there for 3 years. After 3 years, they are transferring you.
Yes.
So what is the malignant exercise?
No, only thing, my lord. So far as the tribunal is concerned, my lord, tribunal is referred to all the decisions of the Supreme Court.
Yeah.
But I'm not considered saying that it is within their domain. The domain, my lord, was not on the challenge. The challenge is, my lord, how you are selectively taken out and was posted to a place, my lord, where there is no post available.
No. Where is that order?
Order, my lord, the Annexure 11, the transfer order, my lord, transfer order is Annexure 7. Annexure 7, page 32.
Your name is
Prashant Kumar Sahu.
Prashant Kumar Sahu.
Yes. I was posted to branch office JKpur.
As SMO
branch. That is not a state medical office branch. Branch office JKpur. ESI corporation. I was posted from Bhubaneswar. I was posted to branch office JKpur. If you also look at the branch office JKpur is concerned, there is no vacancy that I have shown to the authority. Well, kindly come to page Annexure 8, page 34. Just next page, page 34. Serial number 13. JKpur Mela. Manager grade 2-1, assistant head clerk 0, UDC cashier 1, MTS 1. So there are only 3 posts. So there is no post there, Mela, to which I was transferred. Immediately, Mela, the Annexure 9, I filed a representation. Because so far law is concerned, Mela, transfer case law is 24. Mela.
You Annexure 8.
Annexure 8, Mela. It was not current.
Maybe that somebody might have been transferred from that to some other branch. Who knows that?
No, Mela, there is no such case, Mela. Here it is not a case, Mela, to accommodate somebody.
Annexure 8 is what?
Annexure 8, Mela, the branch-wise sanction string.
Serial number 13. Serial number 13.
This is, Mela, revised data, upgrade data. I have collected from the office. It is not a case where to accommodate somebody, my lord, my transfer was there. It is not a case like CP Bose and others. And immediately, my lord, because I have to approach the authority first, all the distance and you have to
Where have
approach.
you taken the ground before the tribunal that there is no such post lying vacant there? So where I will be
My lord,
adjusted?
that way, my lord, copy is not filed. If you also call tomorrow, my lord, I'll file the way.
Has that point been raised?
Well,
That is exactly the thing.
You may have filed, but if you don't raise that point, they need not consider.
no, that is correct. That is there. That is there.
Yes, but
The should be particular and senior advocate place for Madden adjournment.
For a minute, my lord, kindly come to page 37. Page 37.
Taking it tomorrow.
Yes, in 37, in my representation also I have taken that.
No, it's all right. We want to see that line.
In your OA also, you have urged that point. Paragraph
Yes.
2, it is there. Next.
Yes, it will come tomorrow.
Well,
By the way, who is appearing for?
I am appearing for the opposite petitioner one, my lord.
So we will ask you that you in today in the evening hours or during course of the day you take instructions. You know that what point he is raising. Just we are
opposite
asking you.
petitioner 2 to 4 is the
4 weeks fix ନାହିଁ ସେଠି ସେ କହୁଛନ୍ତି ଯେ ସେଠି ତାଙ୍କ ପାଇଁ କୌଣସି ପୋଷ୍ଟ ଭ୍ୟାକାଣ୍ଟ ନାହିଁ ଏ ଯୋଉ ଦେଖୁଛନ୍ତି ଆନେକ୍ସର 34 ରେ ତ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ଜେକେପୁର ଏସଏସ୍ ରେ ପିଟିସନର ଯୋଉ ଆପଣ ଟ୍ରାନ୍ସଫର କରିଦେଲେ ସେ ଯାଇ କୋଉଠି ରହିବେ ଯଦି ପୋଷ୍ଟ ଭ୍ୟାକାଣ୍ଟ କିଛି ନାହିଁ 3ଟା ପୋଷ୍ଟ ସେଠି ଅଛି ସମୁଦାୟ ଯଦି ପୋଷ୍ଟ ନାହିଁ ସେ କୋଉଠି ରହିବେ
ଆପଣ କାହା ପାଇଁ ଅପିୟର କରିଛନ୍ତି?
in opposite petitioner 1, my lord.
1.
Yes, my lord. Opposite petitioner 2 to 4 is
ଖାଲି ଫିସ୍ ଲଗା ଅଛି।
separate.
ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ କିଛି କରିବାର ନାହିଁ ଖାଲି ବିଲ୍ ଦେବେ ଫିସ୍ ନେବେ। Since you are appearing, we'll hear you.
Yes.
Just take instruction today itself, whether there is any vacant post to adjust the petitioner or not. Right?
Yes.
He was serving as you know, the transfer order is there, which Mr. Tripathi has pointed out that the transfer order is Annexure 7, and he was posted in the SMO branch, and he has been transferred to branch office JKPur. He is citing this revised data, and serial number 13 is JKPur SS. ସେଠି ଦେଖୁଛନ୍ତି ଯେ ଏଠି କୌଣସି ତାଙ୍କୁ ଆଡଜଷ୍ଟ କଲା ଭଳିଆ ପୋଷ୍ଟ କିଛି ନାହିଁ ଭ୍ୟାକାଣ୍ଟ ନାହିଁ ତ ଅଛି ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇକି କୁହନ୍ତୁ ହେଲା।
So you are challenging the final order, the interim order?
No, final order.
Final order. Okay.
Interim order was there, madam. Interim order there. They have paid me salary. I was continuing.
Okay. Tomorrow.
Yes.
Item 13.
Landlord, the tenant dispute, my lord. So far as agreement is concerned since 2015.
MCD prayer. MCD prayer.
Item number 15, 14, 746 years. After hearing the parties declare the agreement terminated due to non-compliance of so and so, on further please cancel the said agreement and declare
Dissolve entity.
Petitioners executed a lease deed in favor of the respondent number officer to other private party. Now they want
to form
this court grant the direction to the opening number 1 to cancel that instrument.
My lord, have a glance to see the page 22 declaration of the government to that company as voidable.
No, the High Court will declare it void.
No.
So, if you have executed an agreement and for some reason you want it to be declared as void, then you have to file approach the appropriate forum. Why have you come directly to this court?
My lord, one prayer, my lord. Lordship, have a glance to page 22, the government declaration. This company was declared as void in 2019, my lord. Lordship, may see page 22. Government notification.
Maybe this cannot be adjudicated. The other side has to be noticed if you said that they have flouted
I
some
have
terms and conditions, that
that is
to be
there, my lord. That's why
evidence has to be
private
attached.
company.
private company, all right, my lord. Government of India, lordship may see that page
How it
22.
read to be maintainable? That's you are asking.
My lord, I have filed a representation before the authority.
Yes.
2000, my lord, annexure 2, indicating that the government has declared that this is a private company. Lordship may see that.
The private company. And,
2019 2019 notification of the government. Central government has declared this company, your lordship may see, serial number 730, Utkal Invocare Solution Private Limited. They have cancelled. मोर 500 टंकार भड़ा नहीं थे से टंका भी दबार नहीं.
So the against opposite party number 2, which is a private company. Therefore, we are of the view that said petition is not maintainable and accordingly dismissed.
Item 15.
Yes, Mr. Behra. कौन आसिला? Status of the application.
ଦିଅନ୍ତୁ ସେ ପରେ ଷ୍ଟାମ୍ପ ଟା ମାରିଲା ହବ। ଆଚ୍ଛା ଆଚ୍ଛା ହଉ ହେଇଯାଇଛି ଆଉ। ସାଙ୍ଗସନ୍ ହେଇଯାଇଛି ଠିକ ଅଛି। Representation dispose of ହେଇଥିଲା ନା section 28 application ଦେଇଥିଲେ? ଦେଇଥିଲା application? କୁଆଡେ ଗଲା? ହେଇଛି
Let me know. As for the order dated 6/2/2025, the Land Council for the state has received instruction from Director R&R from Additional Secretary to Government dated 17/3/2025. The पूरा कोई ना relevant question. Which indicates about the sanction of payment of rupees ethically government, which indicates about the sanction of payment of rupees so and so only towards the decretal dues under section so and so in favor of the petitioner. Which is the petitioner.
Land देदेले हो एकर एतिके as per judgment देते हैं ये एतिके करदेले हो first paragraph टा नहीं?
Yes, first paragraph. According to the petition, contempt petition is disposed. अच्छा copy दे ले? सामने दियो तो copy. जब client को देखेगा ना.
Item 16.
17 also matter.
रोज गोटे जाओ जाओ.
सेटा ହେଇଛି कि न ହେଇଛି से कहबे ना?
ना कोन 6 serial जातो हमें we are in item number 16.
Now 16 so आपण टिके अपेक्षा करो।
16 कौन आला?
Last one you also direct file affidavit regarding received the application or mail. This figure when I have filed notice and earlier lordship has been similar matter lordship has appeared. I've already
just a minute directing the Chief General Manager consider the representation of the
सब कहला केबे देले?
my lord is
अच्छा डेट ऑफ हियरिंग गोटे एडा दउ नांती कोन पे एते रेलेवेंट जिंस ओडा दबा करथा ना 12/8 रे आपन डाकी थेले सेटा कहिबेनी
2 ଦେଇଥିଲେ 12 ଡାକିଥିଲେ
सेटा रिट पिटिशन रे कहिबे ना कंटेम्प्ट सॉरी कंटेम्प्ट रे कहिबेनी କହିଥିଲେ ନା ଖାଲି ନଟ୍ କମ୍ପ୍ଲାଇଡ୍? କଣ ଏଇଟା ଦେଇଛନ୍ତି?
Another material also is similar to
Instruction
past.
ଆଣନ୍ତୁ। ହଉ
notice you.
Order the Your lordship, I am pleased to pass another similar matter. Lordship.
It's been disposed of. On the date fixed, the representation of the petition has not yet been disposed.
ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣନ୍ତୁ। ଆଫିଡାଭିଟ୍ କପି ଦେଇଛନ୍ତି?
Private party, my lord.
ପ୍ରାଇଭେଟ ପାର୍ଟି?
It will
ଆଚ୍ଛା ହଉ।
similar matter. Lordship pass an order, my lord. I have given the order. I would send the I have supplied the notice and the lordship is to pass the notice and
ଆମେ ନୋଟିସ୍ ଇସ୍ୟୁ କରିଛୁ ପରା। ସିମିଲାର ମ୍ୟାଟର କଣ ଦେଖିବା ଦରକାର ନୋଟିସ୍ ଇସ୍ୟୁ କରିବା ପାଇଁ?
As for the order dated 18/2/2025, the land counsel for the petitioner has filed an additional affidavit wherein it is stated that the copy of the order dated 2/5/2025 was served on the opposite party of the contender on 15/5/24.
24, my 2524.
24,
Right.
And after receipt of the same, the opposite party issued notice to the petitioner and others on 2/8/2024 and fixed the date of hearing to 12/8/2024. But the representation has not yet been disposed of. The additional affidavit is taken on record. Issue notice to this one, so but we have order adhirosi to as per the representation. Yes, next.
Item 17.
2 weeks ରେ ଆସିବ ନା ଅଧିକା ଦରକାର?
ଏଟା ଫାର୍ଷ୍ଟ ଟାଇମ୍ ଆସିଛି ନା ସେକେଣ୍ଡ ଟାଇମ୍? କୁହା ହେଇଥିଲା ଇନଷ୍ଟ୍ରକ୍ସନ୍ ଆଗକୁ ଦିଆ ହେଇଥିଲା ମାସେ ହେଇଗଲା। You want 2 weeks more time?
3 weeks.
The Land Council for the state seeks some further time to obtain instructions in terms of the order dated 6/2/2025. Is this matter? Is this matter on 8th of April 2025? Yes.
Item 18.
Similar to 16. Similar matter.
କହିଛନ୍ତି କେବେ ଦେଲେ?
Other additional affidavit ଅଛି?
No,
first time ଆସିଛି।
First time ଅଛି।
ମାନେ ଅଛି ତ କେବେ ଦେଲେ କଣ ଅଛି ତ?
ସେଟା ଅଛି।
କୋଉ paragraph ରେ ଦେଖନ୍ତୁ କେବେ ନେଇ ଦେଲେ? ହଁ ଅଛି।
ସେ notice ଟା ଏଣ୍ଡ ଦେଇକି
ହଁ ଠିକ ଅଛି।
ତଳେ repeat ଟା
This contempt petition has been filed for non-compliance of the order dated 2/5/2020.
ଏଇଟା ବି ସେମ୍ as the other one. ଦେଇଛନ୍ତି ଡେଟ୍ ଅଫ ରିସିପ୍ଟ କି କଣ ହେଇଛି କିଛି କହିନାହାନ୍ତି। ଦିଟା ଲାଇନ କହିଦେଲେ
WPC number 26312
same as the first one.
2019.
ଯୋଉଟା କହିଥିଲେ ଯେ affidavit ଦିଅ।
In the order dated 2/5/2024, this court, after hearing the counsel for the parties and going through the records, without expressing any opinion on the merits of the case, disposed of the petition directing the opposite party number 4. Opposite party number 4 kiye thile?
Chairman Itko,
Chairman Itko, to consider the of the representation filed by the petitioner and to pass order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. In this contempt petition, in paragraph number 4, it has been stated that as per the order of this court, the petitioner submitted the court order along with the representation to opposite party number on 15/5/2020. But the opposite party has not complied with the order of this court. The representation has been annexed to the contempt petition as annexure to notice court.
କେସଟା ଦେଇନଥିଲେ ଦେଇଥିଲେ ଆଫିଡେଭିଟ୍ ଫାଇଲ୍ କରିବାକୁ ଆଫିଡେଭିଟ୍ ଫାଇଲ୍ କରିବ ନା ନୋଟିସ୍ କରିବ କଣ କରିବ କଣ
'24 to '25 madam. Okay. Today first time madam. ନହେଲେ right 36 ଯୋଉଟା ଫାଷ୍ଟ ଯୋଉ ଅର୍ଡର ଦି ସେଇଟାରେ ଆଜ୍ଞା ଫାଷ୍ଟ ଆସିଥିଲା ତ ଲର୍ଡସିପ has increased to pass similar order. Pass. এইটাରେ କିନ୍ତୁ ଦେଇନଥିଲି 36 ରେ କିନ୍ତୁ ଆଫିଡେଭିଟ୍ ଦେଇନଥିଲି ସେମାନେ ଆକ୍ଚୁଆଲି ବୁଝିପାରିଲେନି ଭୁବନେଶ୍ୱରରୁ ଆସିନଥିଲା ସେମାନେ କମ୍ୟୁନିକେଟ୍ କଲେନି ଦେଇଦେଲି one pass over item 5 amendment by way of amendment my lord I want to bring the document showing that my land has been acquired. That is the yes twice it's
No, common in nature.
consulate I have with me. ମୁଁ କାଲି ଦେଇଦେବି yes item 24 also same. Item 24 also same. Both the cases were coming together 24 item 24 same thing man. Both are coming together কিন্তু এটা concept से बहुत बहुत यार
Yes, that's one with
Hello, pardon me for mentioning a matter. CRLMA 27 of the 2025 has been listed on the last Friday, that is 13th of March. And next date of showing that 18th of March, but it couldn't be listed and the matter couldn't be taken up on that day. Or this CRLMA is
18th of
filing
March
for the
is today.
restoration.
18th of March is today.
This matter couldn't be listed today and it was saying that 18th of March.
obliged lords. Pardon to mention, my lord, it is a JCR. I has been filed for bail.
CRLA or CRLMP?
My lord, pardon to mention, my lord, it is a JCR. I has been filed for bail, and the appellant is 80 years old man, and is 6 years. It was 6 to 2 p.m.
এইটা তো বর্তমান ওটা দেখো ফার্স্ট ফার্স্ট আইটেম নম্বর 8 টা টেক হইয়া বুঝি তো
Supplemental list, item number 8.
ସକାଳୁ ମନେ ପଡିଲାନି ବୋଲି କି ରଖିଛି।
It is reflected in order dated 11th.
So that whether he will be engaged in that other case.
ସିଆରଏଲ ପ୍ରଥମରୁ ଫାଇଲ ହେଇଯାଇଛି ତାପରେ ଏବେ ଗୋଟେ ଫାଇଲ କରୁଛନ୍ତି କୁଆଡେ ଗଲେ
ଏଇଠି ଅଛନ୍ତି।
ବିଚିତ୍ର ବେଣିଆ କିଏ
ସାର୍ ନମସ୍କାର।
ବିଚିତ୍ର ବେଣିଆ ଆପଣ ଏଇ ଯୋଉ
2022
ଆଡିସନାଲ ସେସନ ଜଜ୍ କଣ୍ଟାବାଞ୍ଜି କୋର୍ଟରେ ଆପଣ ଯୋଉ ବିଚାରର ସମ୍ମୁଖୀନ ହଉଥିଲେ ଏବଂ ଆପଣଙ୍କୁ ସେଠି ଦଣ୍ଡ ଦିଆଯାଇଥିଲା ଏବଂ ଆଜୀବନ କାରାଦଣ୍ଡରେ ଦଣ୍ଡିତ କରିଥିଲେ ଟ୍ରାଏଲ କୋର୍ଟ ତ ତା ବିରୁଦ୍ଧରେ ଆପଣ ଯାହା ଜଣା ପଡୁଛି ପ୍ରଥମେ ଗୋଟେ ଜେଲ କ୍ରିମିନାଲ ଅପିଲ 2022 ମସିହାରେ ଫାଇଲ କରିଥିଲେ ସେ ଜେଲ କ୍ରିମିନାଲ ଅପିଲରେ ସବୁ रेडी ହେଇଗଲାଣି ता देरे वकील मध्य माने एंगेज ହେଇଛନ୍ତି ବା नियुक्ति ହେଇଛନ୍ତି पुणी एबे आउ थरे ए 2024 मसिया रे पुणी आउ थरे गोटे क्रिमिनल अपील कोन पई फाइल कले बुझी पारछो ना नहीं आपण 2022 मसिया रे गोटे क्रिमिनल अपील सेही दंडादेश को विरुद्ध करिकिनी बा चैलेंज करिकिनी कले एवं सेटा विचार पई रहिछि पुणी आउ गोटे काहे कि क्रिमिनल अपील दाखल कले आपणकर वकील
पळेले पळेले पळेले
पळेले
पळेला लिंक पळेला घंटा बेंजी सब्जेक्ट आउथरे टिके मारले क्लिक सेठी सही हां ठीक अछि लिंक टा पळेथिबो आउथरे आसीबो सुबुची हां अच्छा दियो आपण जेल रु चिट्ठी देइथिले से चिट्ठी ऊपर एठी गोटे अपील नंबर हे कि हला आ ताधर वकील नियुक्ति हेचंदी 2022 रे तापरे एटा द्वितीय अपील टा आपण करचंती तंदी दीटा अपील हेई परिवनी सेथि पे आपण को आज डका हेची से वकील से
आपणकर जो वकील एबे नियुक्ति करिसंती गौतम कुमार राउतराय जे कि आपणकर अपील टी दाखल करिसंती आमे तांकु से जो जेल क्रिमिनल अपील ले तांकु नियुक्ति कर दबु आ कारण ए जो क्रिमिनल अपील टा एबे दाखल करचंती ता धीरे 1253 दिन विलंब हेची बेली हमर ऑफिस पॉइंट आउट करूची
पुणे फटी गला तो फोन रे कथे जो ना कोन करे लिंक टा खराब अछि मजे मजे कटि जाउची सो लेट अस फाइंड आउट वेदर ही कैन हियर एंड देन टेल हिम
अच्छा
मैं आछी जे पुणी पळुची आपण को सुबुची
अनम्यूट करंतु
आमे आपण को सुनी परनो सेठी अनम्यूट करंतु आपण को सिस्टम रे अनम्यूट करंतु आपणकर कथा सुबुनी ते आपणकर जो स्क्रीन अछि ता धरे गोटे माइक्रोफोन थिवो सेटा को दबांतु माइक्रोफोन रो छवि थिवो सेटा को क्लिक करिवे
सर मते बेल बुला दरकार बेल दे दो
हां एबे कोंतु
तो लगा गौतम को गोयल के धरा आइছে আর बीमार भी এই গনি নমে
गौतम राउतराय आपणकर वकील रहिबे तो
हां
ठीक अछि हो
ठीक अछि गौतम राउतराय आपणकर वकील रहिबे
हला तो कोन
हला
ठीक अछि
सेति के आपन दरकार तो से आपणकर केस से करिवे
नहीं यार गौतम कुमार गोयल के बेल दे दो ना या मते
हुई गौतम
बेल दबा गौतम राउतराय
आपण वकील को देख पारछन तो छिड़ाइचंती आपण
बेल दरकार होचन नै नै एबे जो अपील टा फाइल करछनी आपण तो गौतम राउतराय को देइचंती केस गौतम कुमार राउतराय हां सॉरी गौतम कुमार राउतराय
आपण सामने रे छिड़ाइचंती वकील बाबू देखंतु से ये देखि पारथिबे
आपण दुसुची से छिड़ाइचंती कोर्ट रे छिड़ाइचंती नहीं तांका पाखे नहीं कि से देखि देले आपण पाखे नहीं कि स्क्रीन टा दुसुनी जेलर बाबू आपण को दुसुनी तांको देखै दियंतु से वकील छिड़ा हिचंती देखले जने मैडम छिड़ा हिचंती आ वकील बाबू जने छिड़ा हिचंती देखले तो हां से आपनकर वकील से आपनकर केस करिवे
ठीक
ठीक अछि पुणी कटि जो
लेखन ना दरकार नै पैसा लेखन दितरे order number 4 for example in pursuance of the order dated 11/3/2025
फोन नंबर अपन अछि त फोन नंबर तांक संग जोगाजोग अछि
the appellant Vichitra Benia appeared through virtual mode from the jail and stated that if in the jail criminal appeal number 2 of 2022 Mr. Gautam Kumar Rautray, advocate, to whom he has preferred this criminal appeal 1312 of 2024, challenging the self-same impugned judgment and order of conviction passed by the Learned Additional Session Judge Pantavanji in Sessions Case number 6 of 2018, is engaged as an advocate. He has no objection. Stop. In view of such submission, this criminal appeal
delay କଥା ବି କହିଦିଅନ୍ତୁ।
This criminal appeal is disposed of and stop कर दियंतु तापर जे सीआरएल टा थिबो जे सीआरएल रेकॉर्ड टा करतम 2 of 2022 आज का डेट पकई देबन in view of the order dated 18/3/2025 passed in CRL number 1312 of 2024, Mr. Gautam Kumar Rautray is engaged as the counsel for the appellant Bichitra Benia. Stop. Mrs. Gayatri Das, advocate, who has been engaged by the Legal Services Authority, is disengaged. Her name shall not be reflected in the cause list henceforth. Have you got another wakalatnama for filing of this in the CRL? Acha. The ये करछु अपन आनी फाइल कर दो. Let the wakalatnama be filed in this criminal appeal JCRL by Mr. Rautray. Stop. You do one thing, since either you obtain or we'll ask him to obtain that. I would wakalatnama upon private.
There is a blank wakalatnama available in the record, JCRL record.
Achhi, dekhi.
No, it is available here. That may have been used by Madam Gayatri. So देखिए the physical record has to be checked. The scanned one check करके.
Blank wakalatnama achhi.
Physical record अच्छी देखो.
अच्छी तो.
Judgment तले. अच्छी.
अच्छी तो होती है तो.
सेटा कोई दूना नहीं सीखता.
हाँ. तो फिलो भी जो blank के. कौन बुझी पाना दी उड़िया. अपन को जो blank wakalatnama अच्छी ना हम टमाटर दूँगे.
Oh.
Lebon. File wakalatnama. I would wakalatnama magi on that one. It would be easier for you. The Learned Counsel for the state shall.
Yes, it is magi file करी और तंग होगा ना. से engage करते हैं तंग.
So you jail no. तो leave file wakalat. Chal. Okay.
Personal appearance distance.
Personal appearance of Swanpur is distant.
ठीक अछि आपण वकील संगे आपण कथा हेबे हला एबे पे के सरला
ଆପଣଙ୍କର ଯୋଉ advocate କୁ engage କରିଥିଲେ ବା ନିଯୁକ୍ତି କରିଥିଲେ ସେଇ ଓକିଲ ହିଁ ଆପଣଙ୍କର ଯୋଉ ଆଗରୁ ଯୋଉ ଜେଲ୍ କ୍ରିମିନାଲ appeal ଟା ଅଛି ସେଇଥିରେ ହିଁ ଆପଣଙ୍କର ଓକିଲ ଭାବରେ ନିଯୁକ୍ତି ହେଲେ ଏବଂ ସେଇ ହିଁ ଆର୍ଗୁମେଣ୍ଟ କରିବେ ହେଲା ଗୋଟେ ଓକାଲତନାମା ଆପଣଙ୍କର ଓକିଲ ବାବୁଙ୍କ ପାଖକୁ ପଠେଇ ଦେବେ ଠିକ ଅଛି ଚଲ
Item 1.
Your Lordship may kindly teach.
Namaskar.
Your Lordship may kindly.
Yeah. What is your name, Learned Counsel?
Krishna Chandra Mohan, my lord.
You are appearing through Mayurbhanj. Let's add Mr. Krishna Chandra Mohanty, Learned Counsel, appearing through Virtual High Court, Mayurbhanj at Baripada. Admit, call for the trial court record. IN number so and so. This is an application for bail since one of the offense under which the appellants offenses have been found guilty is under section 376 DA and 6 of the POCSO Act. That extra copy of the appeal memo along with the interim applications be served on the land council for the state, which will be sent to the inspector in charge of Kunta police station for its service on the informant in Kunta PS case number 1 dated 5/1/2019. Interim applications shall be listed on such and such date for consideration. The land council for the state shall obtain the confirmation letter regarding service of notice on the informant in the meantime. ଆପଣଙ୍କର ଏଇ ଯୋଉ ଅପିଲଟା ଆଡମିଟ ହେଲା ଆଉ ବାକି ଯୋଉ ଏକ୍ସଟ୍ରା କପି ଯେହେତୁ 376 DA ଅଛି ତ ଏକ୍ସଟ୍ରା କପି ଅଫ ଦି ଅପିଲ ମେମୋ ଆଉ ଇଣ୍ଟ୍ରିମ୍ ଆପ୍ଲିକେସନ ଦିଟା ଯୋଉ ଫାଇଲ କରିଛନ୍ତି ତାକୁ ତାର ଗୋଟେ କପି ସର୍ଭ କଲେ ସେ ନୋଟିସ ଯିବ ଇନଫର୍ମାଣ୍ଟ
Obliged, my lord.
Item 2.
May I please your lordship? The appeal is within time.
Yes. You are Mr. Behra.
Arun Kumar Behra.
What is the conviction?
It's a life imprisonment and fine of rupees 50,000. These are two of the IPC.
Right. Or Mr. Arun Kumar Behra. Admit you through virtual high court. Baleshwar. Admit call for the trial court report. Interim applications for bail and stay relation of time to be considered after receipt of the trial court report. Yes.
Another application for bail, interim application for bail.
That will be considered after receipt of the trial court record. In the meantime, you supply the deposition copies of the witnesses to the land and council for the state. Se faster mucho se
Item 3.
Conviction part admit कर दिया उनको. Call for the trial court record. Madam, you are filing this. Next.
Item 4.
Lordship has directed take instruction as to the medical condition of the parents of the petitioner. Lordship has directed to take instruction as to the medical condition of the parents of the petitioner. I request some more time.
Round of element of the parents of the petition. 11-3 order was passed.
Yes, sir.
2 days.
The self-some allegation on the self-some documents, he has already been released on bail. I'll just verify whether there are any.
About the present health condition.
Present health condition. Should you grant me some more time?
So next week.
Yes, sir.
Because you have already given 1 week time.
Next week will.
IL number 560 of 2025 is an application for interim bail in the ground of settlement of the parents of the petitioner. Land council for the state seeks some more time to obtain instruction as per order dated 11/3/2025. Put up this matter on 25 payment 2025.
Assuming kindly 26 days.
26 तारीख से होता है. असुविधा 26 को दिन 26/3/2025. Yes.
Item 5.
Aishwarya Das, one of the So the 302 case, have you got any idea how many years of practice Aishwarya Das had?
I'm not sure.
And also he
Not coming.
also practice बड़ा लागू नहीं है उसको. Hmm? Out of matter astra ನಾವು disengage କରାಗಲ್ಲ ସେଇ ground ରେ.
ଏଇଟା କଣ ଇଏ ହେଇଥିଲା
ହଁ ସେ
ଟାଇମ୍ ମାଗିଥିଲେ
engage ହେଇଯାଇଛି first order.
ଲାଷ୍ଟ ଡେଟ୍ ନନ୍ appears ନନ୍ appears କରିବାକୁ ପଡିବ ତାପରେ ଆଉ ଗୋଟେ କାଉନ୍ସିଲ୍
हम जानते हैं ଆଉ ଗୋଟେ case ରେ disengage କରିଦେବୁ. Sudipto has
How many years of practice?
7 years.
How about you? How about you? Huh? Shanti. Huh?
I think that 10-year observation should be included.
ସୁପ୍ରିମ କୋର୍ଟ କହୁଛନ୍ତି ଆମେ କଣ କରିବା କହିଲେ
ତ କେତେ କଥା ଆଜ୍ଞା କହୁଛୁ
ଆପଣ ସେଟା କହିପାରିବେ ଆମେ ସେଇ ଆପଣ ଯୋଉ ଏକ୍ସାକ୍ଟ ସେଣ୍ଟେନ୍ସ
yes without having that
that the appellant wants
Yes.
to do it so that is all right.
and can age or period of practice
No,
be
that
a criterion?
they are also unable to argue that also is there.
Yes, that's what I want.
No, but
live stream talk.
what to do?
Mr. Kinata Mr. आपको enrollment number देंगे. You engage as this one, so the counsel for the appellant, and in case of Miss Aishwarya Das, name of Miss Das shall not be reflected in the cost. The paper will theory, copy of the paper will be supplied to the land council. Get ready, Mr.
Yes, fine. 2023 bail file कर दी, so bail petition ये दिखा
along with the interim application for bail. Bail and stay election. Go through this bail application and the fact you can face it. All right, next.
Item 6.
Kindly adjourn the matter.
Have you obtained instruction?
Yes, sir.
And give a copy to the Land Council for the state IN number 380 of 2025. The Land Council for the state has received the instruction as for the order 4/3/2025. The instruction is taken on record. Instruction is taken on record. Stop. Copy of such instruction has been stopped on the Land Council for the appellant to 6 for an adjournment. of this matter କେବେ ରଖିବ କୁହନ୍ତୁ?
So 20th April, madam.
ନଥିବ is he out of station? ଆଚ୍ଛା country ବାହାରକୁ ପଳେଇଛି
22 ତାରିଖ
ଲେଖି ଦିଅନ୍ତି ସମୟ that Mr.
Yeah, and
So it
suggest
may be
that
listed
the
after.
matter might be taken up after 20th of April
As Mr. Mishra is out of station.
2025 as Mr. Mishra is out of station. Put of this matter.
Interim bill he could have also argued by himself. ঠিক আছে
22/4/2025 कर देना. Yes.
Item 7.
Here Mr. Das ଆପଣ ନାଁଟା ଦେଇଛନ୍ତି ହଉ all right.
Item 7.
Please, your lordship. The last occasion I had placed the materials. The appellant has been convicted on section 303. The case of uxoricide, alleged uxoricide. And the only material, my lords, is an extrajudicial confession alleged to have been made before PW6.
There is a recovery of weapon at the instance of the accused.
No, recovery. And bicycle would.
Deceased.
Deceased is the wife of the husband.
What were the injuries?
Injuries, my lords, he has sustained head injuries. They are discussed in the judgment.
PW 24 is the PM doctor.
No, Mr. Panda, in such type of cases, there used to be that you were staying together, last seen, etc.
Yes, but here, my lords, there is no evidence led Para 9 and 11.
Amable. It is a fact that Shivani had been ill and as such was weak prior to the occurrence. It is not a fact that as such by falling on the ground, sustaining injuries and succumbed to it, and I am deposing falsely. In paragraph 11, it is said, it is not a fact that I have not stated before the police that I found accused Dilip was coming holding a bamboo lathi, and that when I asked him where he was going, he gave a push and left the place, and that I returned to my house and informed the matter to Sarpanch, to my family members. And
That has been put to the IO. The IO is PW 26.
Worship, paragraph 12 of the PW6 here. May I continue? Paragraph 12 of the PW6 deposition. After completion of the inquest over the dead body, IO examined me and recorded my statement. It is a fact that at the time of examination, I have not stated that one day in the year 2020, while I was in my shop, my nephew Ghanshyam came and told that there was a quarrel in the house of Dilip and requested me to go there. And that immediately I rushed to his house, and near his house, I found accused Dilip was coming holding a bamboo lathi by bicycle. And I got down from my cycle there, and then the accused Dilip disclosed before me that he assaulted Shivani and killed her. And I asked him where he was going. He gave a push and left the place. Then I went to his house, found Shivani was lying dead inside the outer house of the accused, sustaining severe bleeding injuries on her person, and accused Nishamani was sitting nearby. And I returned to my house and informed the matter to Sarpanch.
Fortunately, he admits that she has not stated all these things before the IO. Is it a correct statement or not? Have you verified that 161 statement?
I'll just check it.
Mr.
It has been put to the IO, Millets.
No, this is he has it is a fact that he says admits. No question of putting the IO. It is not that it is not a fact. It is a fact that at the time of my examination, I have not stated all these things to the IO. That means he is deposing for the first time in court. So,
paragraph 11, they have said it is not a fact that I have not stated before the police.
Which one?
Paragraph 11.
Come to paragraph number 12. You
12,
just now placed it.
Yes, sir.
He says that it is a fact that at the time of my examination, I have not stated all these things which she has stated before the police in court during the examination in chief. She admits that I have not stated in my examination before the IO. This is her statement. That means this statement which she has made in the court is for the first time she is implicating.
Paragraph 11 says otherwise. I'll just check with the 161 statement.
Go through the 161 statement.
Yes,
and please check that this presupposes this admission that I have not stated means he is deposing for about the appellant's involvement for the first time in court.
So paragraph 11 he has stated otherwise.
No, you check.
I'm asking you, please go through the 161 statement.
Yes, I'm not trying to
161 statement is available in that. Is PW6 or na kono?
Bipin Patra. If a Gotti is the only witness. That is why, my lords, what I am saying is, ये जो क्रॉस रे ताको पचराई ची पैरा 5 रे, why that is relevant I am saying. Would your lordship look at para 5?
Yes, just a minute. Nine 161 ଅଛି statement. এটা ନୋଟଟା ବୋଧେ omit ହେଇଯାଇଛି.
କଣ୍ଟିନ୍ୟୁଅସ୍ ପଚାରିଲେ ତ ସେଇ ଟାଇମରେ ଏଇଟା ସେଇଟାରୁ ନୋଟଟା ଯୋଉ ଆରମ୍ଭ
ଏଇଟା ଆଉ ଗୋଟେ ଦିନ ହେଇଛି ସେଟା
ବାସ୍ ତୁ ସେଇଦିନ କହିଥିଲୁ କି ତ ସେଇଟା
এটা omit ହେଇଯାଇଛି not what maybe that he is denying but say
ହେଇଥିବ ଆଉ ଥିବ.
May I read the 161 statement of the
161 Dexalon. You have already seen that she has stated all these things before the IO. But এই যেটা আপন paragraph 6 টা place করেনি
12
কোন 12 টা W6 না
yes sir
PW6 ର paragraph 12 ରେ ଖାଲି it is जो a fact ଜାଗାରେ not a fact ଖାଲି ଗୋଟେ not word ଟା use କରିଦେଲେ ଠିକ ଅଛି।
ସେଟା ଗୋଟେ ସେ କହିଛି ନହେଲେ 2020 ରହିଯାଇଥିବ ଦେଖି ଦଉନାହାନ୍ତି 161 ରେ କଣ କହିଛି
He
ପଢିଲେ
was examined twice, on the date of inquest and on the date thereafter, and on the next day thereafter.
जो 1 day in the year 2020 ସେଇଟା କହିନଥିବ ବୋଲି ସେ whole sentence ଟାରେ ରହିଯାଇଥିବ। Yes,
Is there are two statements?
No, there is only one statement dated before the after the inquest.
That is 2010-2020 जोटा अच्छी आमे देखुछु
2010
हाँ 2010-2020 रे ए स्टेटमेंट टा आमे देख सारलुनी से स्टेटमेंट रे कहिछि आउ को दिन ताको पचारथिले have you found out that Mr. Panda please see that page number 310 से ऊपर लिखा है 310 out of 405 ऊपर गोटे मझी गोटे पेज नंबर दिया है गोटे आरो मार्क ऑफ है डाउन है सेठी पेज नंबर दिया है 310 पेज को पढ़े आसन अरे पेज नंबर की आपको दे दो ना सिस्टम ऊपर पेज नंबर पाइलो
310
मोर नाम विपिन पात्र
हाँ नहीं we have seen that
28-10-20 रे एटा है
28-10 when the occurrence took place when
occurrence has taken place Millers
23/10/2020
हाँ 24-10 रे होती occurrence माने 24-10 रे inquest है
inquest में he is a witness
हाँ
the inquest he is a witness and he has not stated these things. That's what he is saying at paragraph 12.
inquest से नाटा कौन PW6
विपिन बिहारी पात्र
विपिन बिहारी पात्र 8 नंबर 9 नंबर लिखा है
10 नंबर कॉलम
नहीं नहीं 9 नंबर कॉलम टाइप ओपिनियन ऑफ द
न
विटनेस
हला करी कि श्रीकांत महापात्र
तो फाइल इनक्वेस्ट रिपोर्ट फाइल
मुत्तफी मोर झियो शिवानी महापात्र को
पैराग्राफ 9 पैराग्राफ 9 ओपिनियन ऑफ द विटनेसेस रे लिखा है
मुत्तफी मोर झियो शिवानी महापात्र को ब्रैकेट रे प्रधान तार स्वामी दिलीप प्रधान और सासू निशामणि प्रधान ଯୌତୁକ ପାଇଁ ଗତକାଲି ଦିନ 3ଟା ବେଳେ ପିଟି ପିଟି ମାରି ଦେଇଛନ୍ତି ଏଥିରେ କୌଣସି ସନ୍ଦେହ ନାହିଁ ସାଇନ୍ଡ ଶ୍ରୀକାନ୍ତ ମହାପାତ୍ର ତଳେ କଲମ ତା ତଳେ ଦସ୍ତଖତ ଅଛି ବିପିନ ବିହାରୀ ପାତ୍ର
ସମସ୍ତଙ୍କ ଦସ୍ତଖତ କରିଛି one of them is PW6 এবং what is the evidence of the IO whether he has recorded the statement on that day IO is PW
25 PW25 has said at paragraph 2 on the same day I examined the witnesses at the spot. We have not stated
inquest kala
para 3 on 24-10-2020 I held inquest over the body of deceased in presence of Lakshman Dale, additional Tahsildar Dhekana. Exhibit P1/5 PW13 already marked is the inquest report. P1/825 is my signature. I examined the executive magistrate Lakshman Dale and other witnesses to the inquest. I dispatched the dead body for its postmortem exam. কি হয়েছে? Para 20 of the cross-examination of IO, my lords, miss. What he has stated is, it is a fact that PW6 Bipin Bihari Patra has not 25. PW 25 is para 20. It is a fact that PW6 Bipin Bihari Patra has not stated before me that accused Dilip was coming holding a bamboo lathi, and that on asking him, he gave a push to him and left the place.
ହଁ ସୋ ସେତିକି କହିନି ତ ପୁsh ଆଉ ଇଏଟା କହିନି ବଟ୍ ମାରିଛି ବୋଲି ସେଇଟା ତ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ନାହିଁ
has not stated that Dilip was coming. Dilip ଆସୁଥିଲା ବୋଲି ବି କହିନି, bamboo lathi ଧରିକିରି ଆସୁଥିଲା ବୋଲି କହିନି, and on asking gave a push to him and left the place. ସେଥିଲାଗି the relevance is of the cross examination at paragraph 6. Para 5
extracted in the that paragraph 12.
Yes,
it has been rightly that on the date of inquest, he was present. He is a signatory to the inquest report, and he admits that on that day I have not stated. Otherwise, his statement could have been recorded on the very day.
Yes.
The statement he gave for the first time
on
28th, which is after 4 days. So that is the submission of Mr. Panda. So that this witness, how many years you are in?
I am in custody, not so much, because the occurrence, I was arrested on 23/21.
4 years.
And I faced the trial. At the last part of the trial, the court granted me bail after I was given interim bail twice for 1 month periods.
No. What period?
For a period of 5 to 6 months, I was on.
You do one thing, obtain that custody certificate.
Yes.
So this is the argument practically, because the case is based on circumstantial evidence, and PW6 evidence of PW6 is material.
That is the
only material. Of course, the homicidal death is not disputed. And so just obtain that custody certificate.
And the girl has, minor daughter has also stated that death was due to.
She was at that particular time, she was 2 years old. She was
164 she has stated. 164 she has stated that Bappa Marila. But in court she was staying with her grandmother.
What about the child? Where she is staying now?
Now with her paternal aunt.
That I have to take in.
Also that is.
With her paternal aunt. You know.
I'll take it.
I know the Mr. Devasi's Panda Land Council submits that the for some period.
164, 161.
For some period.
161?
164.
For some period, the appellant was the appellant was
yes. The
appellant was taken into judicial custody.
On 20th of March
2021, and for some period he was granted bail by the London Trial Court. He further submits
twice by this court for 1 month.
He was granted interim bail for some periods by this court as well as by the trial court.
As well as by the trial
court. He further submits that the minor daughter of the petitioner, who has been examined in this case as PW17, is also now staying
she is staying at Talcher in the house of the sister of the married sister of the.
He is not staying in the house of the petitioner. He is not staying in the house of the petitioner, but staying in the house of the in-laws of the petitioner.
House of the married sister of the appellant.
Married
sister of the petitioner. Let the of this matter on such an land council for the state shall produce the custody certificate and also obtain instruction about the status of the daughter of the petitioner. Here.
Your lordship fixes to
15.
We'll fix a date, we'll give it.
a free copy of the order.
Free copy of the order.
Item 9.
Yes, Mr. Naik.
Yes, please. Appeal from the jail, my lord. Condemnation for delay, there is a delay of 2953 days delay.
2953?
Yes, ma'am.
What was then?
Yes.
Oh, that case.
Yes, ma'am.
ମନା କଲା
ମୋର ଓକିଲ ଆଉ ବାହାରୁ ଅପିଲ କିଛି ଲେଟର ମାଇଲା ଲେଟର ଲେଖିଛି ମୁଁ ମୋର ଓକିଲ ଆଉ ଉକ୍ତ କେସ୍ ବାହାରୁ ଅପିଲ କରିବା ପାଇଁ କହିଥିଲେ କିନ୍ତୁ ଓକିଲକୁ ଅଧିକ ଟଙ୍କା ମାଗିବାରୁ ଘର ଲୋକ ଅପିଲ କରିନଥିଲେ ମୁଁ ଏବେ ଗରିବ ଲୋକ ହୋଇଥିବାରୁ ଅପିଲ କରିବା ପାଇଁ ଅକ୍ଷମ ଥିଲି।
We have also the recommendation has also been made for his premature release on completion of 14 years of sentence. That also we have mentioned in that order dated 4/3/2025.
You were not there last date, so it was engaged, so it was adjourned. All right. It was adjourned, that is why.
IN number 83 of 2025 is an application for condonation of delay. As per the order dated, report to Rastala order. As per the
4/3/2025 is the last order. Order
11/2/2025, and the London District Judge Baleswar, so also jail superintendent would the so also the jail superintendent, District Jail Baleswar, has submitted their reports. So since the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay in filing this jail criminal appeal. Accordingly, delay is condoned. Hard admit call for the trial court reform. The interim application for bail shall be considered after receipt of the trial court reform. The registry shall supply. You have received that appeal memo. Appeal memo means you got a chittita ase. Business petition. Painanti bote. Achi. Acha, the Land Council for the appellant, so also the Land Council for the state can take the deposition copies of the witnesses after the trial court record is received in their respective pen drives. Apamane asila pore nejibe pen drive. So it would be necessary for arguing the bail application. Yeah. I hear out a date they will do bail application. ये थिले रेडी थिले बड़ा It's number 4
Mr. Naik, what item 2 we had heard yesterday?
That has been fixed to tomorrow.
Yes. No. One thing crossed our mind that the Learned Council was mentioning she's in custody for almost 19 years. Na kete bolte?
2009.
So more than 50. Kete hoji?
Maybe
he was forwarded to court on at a second item to her.
Second,
he was forwarded to court on 13/9/2006. So practically 19 ବର୍ଷ ହେଇଗଲାଣି तो सी माने तापाई किसी प्रीमैच्योर रिलीज होरिया ହେଇଛି କି ନାଇଁ ଏ ବିଷୟରେ ବୁଝିଲେ
phone ରେ ପଚାରି ଦିଅନ୍ତୁ ହେଲା କାଲି କୁ ଅଛି ତ phone ରେ ପଚାରି ଦିଅନ୍ତୁ but they should give the instructions to you in writing, email, whatever.
that he is in କୋଉ jail ରେ ରହିଛି
ଦେଖିଛନ୍ତି
वकालतनामा साइन ହେଇଛି କୋରାପୁଟ
ତଥାପି କୋରାପୁଟ ବାଲାକୁ ପଚାରି ଦେଲେ ଆଉ କୋଉଠି ଟ୍ରାନ୍ସଫର ହେଇଥିଲେ ବି
ସେଠୁ ବି ବୁଝିଦେଲେ
ଫଲୋ ଅପ୍ 19 years ଗୋଟେ ଲୋକ ବସିଛି without doing any ମାନେ ବେଲ୍ ଫେଲ୍ ନ କରିକି
नौर अपील जब बार एडमिशन होला तापर आवर आसीने टोटल फर्स्ट टाइम आसला 2023 रे इंगेज कर काले से जो प्रीमैच्योर रिलीज ହେଇଛି 14 years से ହେଇଗଲାଣି ନା ତ କଣ ହେଇଥିବ ନେଇ ଆସିବେ instruction. Yes, Mr. Jafrullah, what is your item?
Item number 12.
12 ଟା କରିବେ. ଗୋଟେ ପାହାଡ ଥିଲା ସେଦିନ କହୁଥିଲେ କୋଉ ମ୍ୟାଟର ଟା ଗୋଟେ
ଏଇଟା କି
ଏଇଟା ସେଦିନ ଆରମ୍ଭ ହେଇଥିଲା ଅଳ୍ପ ଆଉ ଗୋଟେ ଯୋଉ ସତ୍ୟ ମିଶ୍ର ସାଙ୍ଗରେ ଆଉ ଗୋଟେ
ଏ ତ ନାହାନ୍ତି ଆଉ କଣ କରିବା
ନାଇଁ ଯିଏ ନୁହଁ ଆଇଟମ 12 ର ସେଟା ଦେନ୍ ଲେଖା ଦିଏନି Code 49302.
କହିଥିଲେ ଲାଷ୍ଟ ସେଟା ସିନପସିସଟା କହିଥିଲେ କୋଉ ସାର୍କମଷ୍ଟାନ୍ସରେ କିଏ କିଏ ଉପସ୍ଥିତ ଗୋଟେ ଖାଲି ଚାର୍ଟ ଥିଲା
Yes, କରୁନାହାନ୍ତି ତ ପ୍ରିପେୟାର କରୁଛନ୍ତି ଯେ by the way just FIR ଟା ପ୍ଲେସ୍ କରନ୍ତୁ ତାପରେ ସେଟା ପ୍ଲେସ୍ କରନ୍ତୁ
running page 33 निवेदन 33 महाशय निवेदन एक जे आमे प्रमोद लंका इज इंफॉर्मेटिव PW12 my lord with the son of the deceased
he has killed his father
madam
it's a case of patricide
ना ना गाँव आउ जड़े तार केस होची माँ मरी गला ये इनफॉर्मेट होची पुओ पुओ बहु जाइथिले तार
आपण कहले पिता होची शरद लेंगा आपण कहले ही इज द डिसीज सेहि पे मु
ना ना डिसीज ही इज द डिसीज सन इनफॉर्मेंट
तो ये जाई कि मार देथिला हां हां तांग फैमिली को रेप केस जे तानारे देथि
PW12 होची इनफॉर्मेंट हु इज द सन ऑफ द डिसीज
ओ इनफॉर्मेंट इज द सन ऑफ
द डिसीज
सो एलिगेशन वाज तांग बहु को रेप करथिला
से आगुर गुटे हेतिला तापर से सबले थ्रेटेन
करथिला जे
जागल घटना दिन नथिले जण पुओ बहु नथिला घरे डेड मरला पर पुओ आसी की एफआर
हां माने धमकी थिला दे हैड गॉन समवेयर कोन ओडे अर्जेंट दरकार थिला
जस्ट रीड दैट एफआर वंस
निवेदन एक जे आमे प्रमोद लंका ता स्वयंसो आपनका पाखरे गुआरी एई करे कि मु रविवार शेष रज 16/6/2013 रिख दिन मोर स्त्री मो स्त्री सहित ससुर घर को बुलिबा को जाइतिले स्त्री वाइफ इज PW9 सेठारे रविवार और सोमवार रहितिले आज मंगलवार सकाळु मु खबर पाइली जे मोर मां को मारी दिया जाइछि मु और मोर स्त्री संगे संगे आम घर को फेरी देखिली जे मोर
मां माने डिसीज आउ ये जो शरद लेंगा की शरद लेंगा डिसीज नुहे तो
ना 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 पिता तार पिता बा प्रमोद लेंगार बा
डिसीज को हां ठीक है
मु और मोर स्त्री संगे संगे आम घर को फेरी देखिली जे मोर मां को रेप एंड मर्डर करी दिया जाइछि वर्षे तले मोर स्त्री को नीलू स्वाई प्रेजेंट एपेलेंट नाम व्यक्ति राति रे घरे पसी धर्षण करथिला केस एबे विचाराधीन अछि नीलू स्वाई जामीन रे फेरिबा परे आमको 2-3 थर हत्या धमक देइथिला तुमे केस उठाओ आउ नचेत मु तम संगे तमर वंश शेष कर देबी तार एही हत्या धमक को अन्य सहयोगी माने प्रोत्साहित करिबा सहित क्लब घरे मद मांस खाई विलंबित राति पर्यंत तामाशा करंती ମୁଁ ଗାଁକୁ ଫେରି ଶୁଣିବାକୁ ପାଇଲି ଯେ ରାତି 11ଟା ପର୍ଯ୍ୟନ୍ତ କ୍ଲବ ଘରେ ସେମାନେ ଫିଷ୍ଟ କରୁଥିଲେ ଏବଂ ତାପରେ ଯୋଜନା କରି ମୋ ଘରେ ପଶି ଆମ ମାକୁ ବଳାତ୍କାର କରିଥିଲେ ଓ ତାପରେ ତାକୁ ବାଡେଇ ମାରି ଦେଇଥିଲେ। Nilu Swai and Debagoda. But he faced in furtherance of your common intention and hereby committed offense punishable under section 302 by 34 IPC with cognizance. The third person is in the next page. He faced trial along with that. Second, third charge is that third on the said date and place offense of murder was committed by Nilu Swai and Pramod Nilu Swai alias Pramod Swai and Debagoda alias Vasudev Das, and that you harbor the Nilu Swai and Debagoda knowing that at the time of said harboring, said Nilu Swai and Debagoda had committed murder of the deceased Sumitra Linka in furtherance of your common intention and thereby committed an offense under section 212 34 IPC. So this mainly in the charge in the two head Nilu and Debagoda all three faced trial. And trial court acquitted
जो ट्रायल ये जो accused को
आज्ञा
ताकू मध्य 449 by 34
आज्ञा सेत्रे भी ताकू चार्ज
302 by 34 आ सहित 212
रे एक्स्ट्रा ताकू चार्ज
right
हार्बरिंग पाई
हां in addition to 449 302 I would charge
212
so what happened in the trial court who has been acquitted
in the trial court malad all three phase trial finding is paragraph 20 in the result I find the accused persons namely Debagoda alias Vasudev Das and Rabindra Kumar Dhar not guilty of offense under section 449 302 212 by 34 IPC and as such they are acquitted thereof 235 on CRPC. Similarly accused Nilu Swai alias Pramod Kumar Swai found not guilty. He was not charged but similarly the accused Nilu and Pramod Kumar Swai is found not guilty of offense under 212 by 34 IPC and he is acquitted thereof. However, he is found guilty under section 449 by 302 IPC as such is convicted there under the accused persons, namely Debagoda alias Vasudev Das and Rabindra Das are on bail. They are stand discharged and from their bail bond and saved.
Okay, so now the two have been acquitted of all the charges.
All charges.
This accused, he was not charged under 200.
No, simply nothing. Separate charge not there by 34 charge.
नहीं 2 and 12 भी हवनी के ना सी निजुग निजे कौन हार्बर करियो
एटा को मोट होल्ड कर
को टिके लिख दे
चार्ज ताकू दे किंतु सेपरेट चार्ज भी नहीं 302 ट्रायल कोर्ट
this is the only charge page or it has been subsequently framed, maybe that charge has been altered subsequently, who knows. ये जो आपनकर पेज 36 परे कारण you see in the judgment page number 2 page number 2 2 ରେ ଲେଖୁଛନ୍ତି ଯେ ସମସ୍ତଙ୍କୁ ଚାର୍ଜ
ଗୋଟିଏ ଲାଇନ ରେ
ହେଇଛି
ଲେଖିଛନ୍ତି।
ଏଇଟା, ତେଣୁ ହୁଏତ ପରେ କେବଳ ଏଇ ଯୋଉ 2 ଜଣଙ୍କ ନାଁରେ ମଧ୍ୟ ହୁଏତ ଚାର୍ଜ ହେଇଥିବ
212 ର ଚାର୍ଜ
212 by 30।
ଏନସିଆର
Page 36 ରେ that is the date was 29/1/30
ହଁ
କିନ୍ତୁ ଏଇଟା ଅଛି 5/2
5/2 କୋଉଟା?
37 ସେକେଣ୍ଡ ଚାପ୍ଟର ରବିନ୍ଦ୍ର
ସେଟା କେବଳ ଜଣକର ରବୀନ୍ଦ୍ର ଧଳର ଚାର୍ଜ ଅଛି।
ହଁ
ରବୀନ୍ଦ୍ର ଧଳକୁ 212 ଏକ୍ସଟ୍ରା ହେଇଛି।
ଏକ୍ସଟ୍ରା ଚାର୍ଜ
ଏକ୍ସଟ୍ରା ହେଇଛି ନାହିଁ, ତାପରେ ରେକର୍ଡ ଦେଖିଲେ ଜଣା ପଡିବ ଏଇ ଯୋଉ
ଜଣା ପଡିବ, କିନ୍ତୁ
ଇଏ
ଗୋଟିଏ ଲାଇନ ରେ ଖାଲି ଲେଖିଲେ ଯେ ଅଲ୍ ଓଭର ଚାର୍ଜ ଇଣ୍ଟରସେକ୍ସନ
ବାଉଳାରେ ଲେଖିଦେଇଛନ୍ତି।
ଏକୁଟାଲ ବି କରିଛନ୍ତି ନା ଅନ୍ୟ 212 ରେ ବି ଚାର୍ଜ କରିନଥିଲେ, ହେଇଥିବ ତା ଭିତରେ ଯଦି ଏନସିଆର
ସେ ଲେଖିଦେଇଛନ୍ତି ଉପରେ, ତଳେ ବି ସେଟା ତାକୁ ଆକ୍ୟୁଟ କରିଦେଇଛନ୍ତି ତା ଦେହରେ ଆଉ।
maybe that
subsequently
ହେଇଥିବ
charge
ଅର୍ଡର ସେଇଟା ଦେଖିଦବା।
ଅର୍ଡର ଥିବ ନା।
ଏଇ ସ୍କାନ କପିର ଅଛି ଯେ ସ୍କାନ, ଆଚ୍ଛା ସେଠି ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ଟା ଦେଖିବାକୁ ଗୋଟେ ସ୍କାନ କପିର ଅଧା କଟି ଯାଇଛି।
ଏଇ ଚାର୍ଜ ଟା କେବେ ଫ୍ରେମ ହେଲା, ଯୋଉ ପ୍ରଥମ ଚାର୍ଜ ଟା?
ଫାଷ୍ଟ ଚାର୍ଜ ଫ୍ରେମ ହେଲା 20 ସେପ୍ଟେମ୍ବର 2013।
20 ସେପ୍ଟେମ୍ବର 2013।
ତାପର ସେଇ ଦିନ 20 ସେପ୍ଟେମ୍ବର 2013 ଆକୁ ମୋତି ଅଛି।
20 ସେପ୍ଟେମ୍ବର 2013 ରେ
ଦିଟା
ତ ସେସନର ମୋର ସିଗ୍ନେଚର ଅଛି 4/5/2018
ସିଗ୍ନେଚର ଟା ଅଛି
4/5/2018।
କଣ ଦିଟା କେସ୍ ଲାଗି ଟିକେ ଦେଖିଲେ କଣ, ଏଇ ଯୋଉ 10/9/2013 ଲେଖା ହେଇଛି ପୋଷ୍ଟେଡ because in both cases Nilu alias Pramod Kumar Swai is the accused। अच्छा तार से पुराना केस टा अच्छा
2011 ସେଇଟା
both were posted on the same day। अच्छा अच्छा
this
कोडिए
is
ना
case number 486 of 2010।
486 of 2013।
हाँ 486 तो फिट जो
486 of 2010 कौन रहा?
13 हवा का था, भूल पके जानते हो।
486
हाँ এটা ভুল provision थी। You come to that
वो डेटा को थे चार
ये जो पेज नंबर 9 को पढ़े सुन से जोटा
चार्ज टा को
चार्ज 20/9/2013।
ठीक है
20/9/2013 रे पेज नंबर पढ़े सुन
बेल टा रिजेक्ट हला
बेल रिजेक्ट हला पर ही चार्ज
एग्जामिन द केस रिकॉर्ड 302 रेड विथ 2012
এটা হচ্ছে বেল রিজেক্ট কলা বেলে তারপরে আর ଗୋଟେ সেপারেট অর্ডর ଅଛି ସେଇ ଦିନ
2009 ରେ ଗୋଟେ ଚାର୍ଜ ଅଛି।
20/9 ର ଚାର୍ଜ ଲେଖା ହେଇଛି accused persons ନିଲୁ ସ୍ୱାଇଁ alias ପ୍ରମୋଦ କୁମାର ସ୍ୱାଇଁ କମା ଦେବଗୌଡ ହେଲେ ପାଇଲେ ସେଟା ତାପରେ ଆଉ ତା ନେକ୍ସଟ ପେଜ ଟା ନେକ୍ସଟ ପେଜ
अच्छा
ଏଇଟା
ओके
accused persons Nilu Swai, Pramod Kumar Swai, Swanso, Devagowda and Ravindra Kumar Dhara, 1, 2, 3। हाँ ठीक है 3 जन produced in the custody had Swanso। I am of the opinion that there is strong ground to believe that accused persons have committed under section Swanso। So accordingly the charge was framed। ଯାହା ଜଣା ପଡୁଛି 20/9/2013 ରେ ହିଁ ଏ 3 ଜଣଙ୍କୁ ଚାର୍ଜ ହେଇଛି। ସୋ ସେଇଟା କଣ ଗୋଟେ ଅର୍ଡର ଅନ୍ୟ ଅର୍ଡର ଦର୍ଶେଇଲା ଏଇଟା ଗୋଟେ କେମିତି 4/5/2018 କୋଉଠୁ ଆସିଲା ଏଇଟା ଗୋଟେ
सेपरेट चार्ज
ରବୀନ୍ଦ୍ର କୁମାର ଭଳ ତ ସେଇଦିନ ଚାର୍ଜ ହେଇଗଲା
20 ସେପ୍ଟେମ୍ବର 2013 ରେ ଚାର୍ଜ
ନାଇଁ ତାପରେ ଆଉ ଗୋଟେ ସେ ପେପର ବୁକ ରେ ପେଜ 37 ନାହିଁ
ସେଟା ତଳେ ଲେଖା ହେଇଛି ଡେଟେଡ 20 ସେପ୍ଟେମ୍ବର 2013 କିନ୍ତୁ ସେସନ ସିଗ୍ନେଚର ଅଛି 4/5/2018।
4/5/2018
ଚାରି ପାଞ୍ଚ ଜଣ ଅଛି ଗୋଟେ petition under 311 I have gone through. Charge dated 20/9/2013 against accused persons Ravindra Kumar Dhar is not something. कौन लिखले? Dated against accused Ravindra Kumar Dhar is not signed by the then PO. The same is signed by me today.
अच्छा जदि वो फ्रेम कर देछि
देखिए
ए पेजटारे से दस्तखत करनथला सेइथिपई से दस्तखत करन
दस्तखत सेटमेंट डेट इछि 4/5/2018
एठी लिखि से डेटेड दिस 20/10 को ये कोन करछि प्रिजाइडिंग ऑफिसर सिग्नेचरटा करनथला ए पेज रे सिग्नेचर करदला
एटी भूल जाइछे
एठी भूल जाइछि सेटा से खाली सिग्नेचरटा कर
करिके दस्तखत लिखिला भी ऑर्डर शीट रे से
so fact remains that the London Session Judge is right that as per the order sheet we find that the charge was framed against all the accused persons under 449, 302, 212/34.
तो हेडिंग टारे अलग अलग
कोडा
जो चार्ज हेड टा एथरे फर्स्ट टू हेड रहिछि सेटा तंग तीन हेड रे
सेटा को टोटल सेटा गोटे हेडिंग हबा कथा इनएडवर्टेंटली जो सेटा हबा कथा थर्डली जेमती आधे रहिछि ना ए जो दी जनक पाखे सेटा गोटे गोटे थर्डली अटैच करिया था सेटा ई जो पेज नंबर 36 रे हेनी जो जदियो ऑर्डर शीट रे लिखा है ऑर्डर शीट रे लिखा है जे चार्ज हला तीनटा ऑफेंस रे चार्ज है
सो ऑल वेयर चार्ज
ऑल वेयर चार्ज 449
so there is no separate charge in respect of the
20/9/2013 रे 449 302 212/34 IPC charge pending. See through अन्य दी जन acquittal हेले of all the charges and appellant was acquitted of the charge under section 212/34, right? So he was found guilty under 449/30, right? Now, what you have written in your this synopsis of the case?
No, खाली लिखी जे जोटा जो सर्कमस्टेंसेस गोटा पैराग्राफ रे डील करा छि से सर्कमस्टेंसेस से कोन विटनेस अछंती पैराग्राफ केते रे अछि से
कोडी सर्कमस्टेंस गोटा डील करा छि को पैराग्राफ रे
पैराग्राफ मतलब पैराग्राफ that has been
Trial court ro judgment ro paragraph
7 रे
7
para 7 trial court has was convicted the appellant has summarized
acha ame apon kuntu there was strong motive of the accused namely Neelu Swain to kill the deceased due to launching of prosecution of rape case against him ए जो circumstance साक्षी किए
एथरे circumstance रे साक्षी होचंती 1 2 4
just a minute PW 1 2
1 2 4
4
5
5
6 8
6 8
9 12
9 12
and also 14
second Allah accused Neelu Swain was threatening the deceased
दीटा गोटे रे डिस्कशन हिच थ्रेटन मोटिव ता ताकर आगुर जे थ्रेटन करतुला
next PW6 had seen accused Neelu standing near the house of the deceased at about 1:30 AM in the relevant night of occurrence yeah there is PW6 only
और PW1 होची से दिन से खल
तापर circumstance PW1 stated that on so in absence of Ritu Singh and her husband accused Neelu Swain had entered into acha सी देखिला एंटर्ड एटाला PW1 ए साखी नाम
ए दुईटा को पैराग्राफ 17 18 रे डिस्कशन कराय छि
तापरे ना आगे साखी उडा कोइ न
आया
accused Neelu Swain had told PW1 near panchayat office that he would murder the deceased ए पॉइंट रे
सेटा भी सही डिस्कशन है जो
PW1 होछि साखी
PW1
से पॉइंट PW1 कोइ थी तापरे मेडिकल ऑफिसर conducted it is PW17 तापरे exhibit 4 reveals on the query made by the IO एटा से IO रोच ओके IO और डॉक्टर भी कहि थियो निश्चय आईओ कितना नंबर सेक्शन
आईओ
PW
PW 22
PW 22 କହିଥିବ ଆଉ ଡକ୍ଟର କହିଥିବ ଏଇ circumstance ଆଚ୍ଛା ତାପରେ there was stain of blood on the swan so এটা হচ্ছে আইও କହିଥିବ
ସେ ବି ଆଇଓ
PW 22 failure of the accused to offer an explanation gala this would be there in the 313 ତାପରେ ହେଲା seized weapon of offense one so were produced in court and were identified by the IO এটা হচ্ছে IO evidence তাহলে PW 22 আচ্ছা so main if we say that you are not disputing the homicidal death of the deceased then it appears that so far as the motive part is concerned and threatening part is concerned, number of witnesses have stated that this appellant, against the appellant, there was a case of rape and the allegation was made that he committed rape on the daughter-in-law of the deceased, right?
Yes.
And he was also taken into judicial custody. And after being released on bail, you were found threatening to the deceased again and again.
See, that rape case occurred in 2011. It is alleged after 7 to 8 months after he taken into custody, he released on bail. Thereafter, he threatened. He was regularly he was threatening.
No,
when occurrence took place in 2013.
The rape case is of the year
2011.
Rape case of the year 2011. When you were released on bail?
That is not.
That you not.
No, but it's that 7 to 8 months.
8 months. Could लिखा है जी?
Evidence में आसुची.
8 months ପରେ bail ହେଲା.
And this occurrence took place in 2013.
Date of occurrence of the present case. तो ये जो थ्रेटनिंग एस्पेक्ट टा जो साक्षी माने କହିଛନ୍ତି ସେମାନେ ଘଟଣାର କେତେ ଦିନ ପୂର୍ବରୁ ସେମିତି threat ହେଇଥିଲା ଲାଷ୍ଟ threat
ଜଣେ ଜଣ କହୁଛନ୍ତି ଯେ 15-20 ଦିନ ପୂର୍ବରୁ and PW9 ଆଉ ତାଙ୍କର PW husband wife PW9 and 12 informant and his wife they are saying that
9 ହଉଛି କଣ husband
9 ଟା husband informant deceased ର ପୁଅ
just a minute deceased ର ପୁଅ ଆଉ
ସେ ବୋଧେ କହୁଛି
ସେଦିନ ବୋଲି ସେ କହୁଛନ୍ତି ଆମେ
ମତେ ଯିବାକୁ ପଡିଲା ଶାଶୁ ଘରକୁ
ସେଦିନ କିନ୍ତୁ ସେଇ ଫ୍ୟାକ୍ଟ ଆଣିବି
ନା PW9 କିଏ
wife
ଯାହା allegation ଯାହା against
rape case
ର victim अच्छा
अच्छा
हाँ ठीक है जी नहीं ये थ्रेट पार्ट का कथा से कौन पूछे हाँ in the last day of Raja festival on the date of occurrence that is on the last day of Raja festival accused came to my house and threatened to withdraw the case or else he would kill each of us. At that time, I got the news of so myself, my
sickness
husband,
of my father,
to my father's house, leaving my mother-in-law's house.
In the said night, my father's house, when myself and my husband were about to start for our own house, but the news from mobile phone, my signal on that somebody has killed my mother.
So if we, Mr. Jafrullah, so when number of witnesses have stated about the threat and the victim herself has also stated, being examined as PW9, that the threat was given just, you can say that 2 days prior to the
date of occurrence.
And
the deceased also stated before the PW 13 ଯେ ମତେ ଟିକେ ଧମକ ଦଉଛନ୍ତି ମାରିବେ
ହଁ ସେ ତ କହୁଛି ମାନେ ସବୁ family to each of us you will kill, that is the
the receipt
Hmm.
PW 14 କରୁଛନ୍ତି ଆମେ ଯେତେବେଳେ ଯାଉ ପେନସନ ଆଣିବା ପାଇଁ ସେଟା କହିଛି ସେଟା PW 14 that is the page 78
PW 14
Mitra Lenka I read my lord I know
Sumitra acha
present in the doc I know the deceased Sumitra Lenka in the year 2013 2 to 3 days after Raja festival I got the information Sumitra has been killed so I went to near the spot and in presence of police I saw marks of the assault all over the body of Sumitra Lenka. In the year 2011 the accused Nilu committed a rape on Ritu Lenka, daughter-in-law, and that is the PW 9. Daughter-in-law of Sumitra Lenka and accused was arrested in that case and was on bail. Sumitra Lenka, the present deceased, once meet me while proceeding to receive her old age pension and apprised me that she was under pressure as the accused was insistent with the rape case against him. The accused Nilu also meet me sometime the death of the Sumitra and stated before me to ask Sumitra to withdraw the case or else she will face the their consequences. So I suspect.
Once
before the murder, before death of the deceased, she also disclosed that before 14 that pressure ଅଛି ଏବଂ
ସେ ଲାଇନ୍ ନାହିଁ ତ କହିଲେ once I met
କେବେ କହିଲା ସେ କହିନି ପେନସନ ପାଇଁ ଯାଉ ପେନସନ ପାଇଁ ଆସିଲା ବେଳେ ସେ ମତେ
ଥରେ କହିଥିଲା ଥରେ ଦେଖା ହେଇଥିଲା
ଏଇ ଯୋଉ ଆର ଭିକ୍ଟିମ ର ଏଭିଡେନ୍ସ ଟା ମାନେ ପାଖାପାଖି ହେଇଯାଉଛି
ପାଖାପାଖି victim and husband is PW 12 informant he is unable to see his evidence that he cannot see PW I have lost my vision I am unable to see but in the FIR neither that so far this lordship's query my lord neither they stated anything to anyone or these things neither he has mentioned in the FIR.
No, FIR towards the bottom he has stated about threat.
ତାପରେ ତାକୁ ବାଡେଇ କରି ନୀଲେଶ୍ୱର ଦେବ ଆଗରୁ ମୋ ମାଆକୁ ହତ୍ୟା ଧମକ ଦଉଥିଲେ ସେଇଦିନ
No, the thing is that this may not be an in isolation may not be sufficient, but if it is coupled with the other circumstances,
that is
we have to see
that I want to
so, one of the circumstances is that this accused was involved in a rape case in which the daughter-in-law of the deceased was the victim. This is number one. And in that case, you were taken into judicial custody and then released on bail. After being released on bail, you have given threat to the family members, if we say, on number of occasions as deposed to by number of witnesses, as you said. And even few days prior to the occurrence also, PW9 has stated that threat was given. That is the evidence.
But one more thing, so far the motive is concerned, that threatened is concerned, there also material has come, evidence has, witness have stated that prior to the date of there is also threat from co-accused Debo regarding possession of the land. That is also witnesses have stated that this deceased was possessing a land. For that reason, there is a motive, there is a threat from the Deba also.
No, we are again telling you that this may not be in isolation.
No, that is that I want to appraisal also.
But against Debo, there is no evidence that he entered into the house.
That compliment. So far the threatened is concerned, that motive against Debo is also
there is no charge of rape. So all those things have to be taken into.
No threat that unless you withdraw the case, we will kill.
So these are the circumstances. One of such circumstances is about we are now assessing the evidence on record about the threat given by threat as simultaneously the motive.
Right? So threat and motive. So what I want to bring to your lordship's notice that another threat also by the co-accused, that is also there by the co-accused Debo regarding possession of land. He is also threatening the deceased. That material was there. Threatened both the accused was there. And when trial court has overruled that part, that the threaten is cannot be considered as a substantive material and acquitted. That things has been also discussed by the on trial. Now, my lord, apart from this witness, this motive, other important two circumstances, my lord, that PW1 evidence and PW6 evidence. Apart from that, neither from the spot, nothing has been seized. No material, neither on any material from the during investigation. No other clue come out during investigation regarding the complicity of the appellant, either blood stain or wearing apparel or any types of material evidence. There is no other.
All the articles have been seized and that was examined.
Set our আমার সাথে কিছু relevance.
Let him finish. Yes.
So this letter. So this, apart from this threatened mallet, this other two circumstances, mallet PW1. May I read mallet PW? Yes. I know the accused persons who are now in the dock. I know Sumitra, the deceased, on 17/6/2013. Sumitra was murdered. On 5/8/2011, Friday in the midnight at about 1 a.m., Nilu Swai, this accused now in dock, trespassed into the house of the Sumitra and forcibly raped Ritu Lenka, the wife of the Pramod Lenka. This is the occurrence of 2011, first occurrence. The inmates of the house, Ritu Lenka, called us. We went into this connection, and there was police case. And in that case, Nilu was arrested and was sent to jail. After being released on bail, Nilu again and again threatened Sumitra to withdraw the case, otherwise she would be murdered. Sumitra used to tell me about the above threatening of Nilu Swai in village. On 17/6/2013, this is the occurrence date. Nilu Swai, in absence of Ritu Lenka and her husband, accused Nilu Swai enter into the house of Sumitra. So, Malak, this line, Malak, has been taken as one of the circumstances. So now, Malak, my submission before Lordship, he stated that on 17/6, occurrence took place in 1789. He stated that on 17/6/2013, Nilu Swai, in absence of Ritu Lenka PW9 and her husband PW12, accused Nilu Swai enter into the house of Sumitra. This is the only line. Whether each time he has entered,
no, he has not stated that he had seen it.
Enter us and pitch in it. PW1.
Mr. Nayak, his statement, he has not seen that. I've seen Nilu Swai entering into the house of the Sumitra. The statement hଉଛି on 17/6/2013, Nilu Swai, in absence of Ritu Lenka is PW9, and her husband, accused Nilu Swai entered the house of Sumitra. ये नॉलेजटा केमती आसला तार एटा केमती को बेसिस रे गला एक तो टाइम कहूनी को समय देखी कि नहीं भी कहूनी he has not stated. He has been also declared
the Panchayat office that he would be murdered.
Then he has also declared
about the threat giving. Threat ro achi both number of witnesses.
Number of threat is there.
We are not. We are now analyzing the evidence about entering into the house of the deceased by the appellant. Evidence record I was present there and I had seen so and so, that would have been, so you dita line particularly
Oh, Aku hostile kardele because he did not say about Debba. That is why he has been put questions by the prosecution regarding threats of Debba. Otherwise, against Nilu, he has supported the prosecution case. Cross-examination I gave statement to police. Seita, correct. Seita gote stray heiki gote kenti gote rahi khali semti re rahi.
Witness must say that I had seen it. or I was present when he entered. ଏମିତି କେମିତି ଏ ଟାଇପ୍ ର ତ ଆସିବ।
ଖାଲି entered into the house ଗୋଟେ
suppose ଯାଇଥିଲା accused entered into the house of Sumitra ସେ କହୁନି ମୁଁ ଦେଖିଥିଲି ବୋଲି ସେ କହିଲା ସେ ଯାଇ ତାଙ୍କ ଘରକୁ ପଶିଥିଲା
17 ତାରିଖ ଦିନ ମାନେ ଏଇଟା ଯଦି ହବ ଓଡିଆରେ ଏଇ କଲେ 17 ତାରିଖ ଦିନ ଯେତେବେଳେ PW9 ଆଉ ତାର ସ୍ୱାମୀ ହଉଛି PW କେତେ
12
PW12 ଏ ଦି ଜଣ ନଥିଲେ ସେତେବେଳେ ଆକ୍ୟୁଜ ନୀଲୁ ସ୍ୱାଇଁ ଡିସିଜ୍ଡ ଘରକୁ ପଶିଲା ୟା ମାନେ ତ ଓଡିଆ ମାନେ ହଉଛି ୟା ନା ତ ଏଇ ଯୋଉ ଜିନିଷଟା ଆସି କହିବା କଥା ଯେ ମୁଁ ସେଠି ଥିଲି ମୁଁ ଦେଖିଥିଲି ଏବଂ ସବୁଠୁ ଇମ୍ପୋର୍ଟାଣ୍ଟ ହଉଛି କୋଉ ସମୟରେ କାରଣ ଘଟଣାଟା ହେଇଛି ଆପଣଙ୍କର ରାତିରେ ହେଇଛି ଇଣ୍ଟରଭିନିଂ ନାଇଟ୍ ଅଫ କାରଣ ସକାଳୁ ଡେଡ୍ ବଡି ମିଳିଲା ସେ ଶୁଣିଲେ ଆସିଲେ ଦେଖିଲେ ତେଣୁ
I've seen that
Yeah, we'll come to that. We are analyzing the evidence of PW1 କାରଣ ଜଣେ କହୁଛି ଛିଡା ହେଇଥିଲି ଆଉ ଜଣେ କହୁଛି ପଶିଥିଲା ସେ ଘର
ଏଇଟା ଏ କହୁଛି ପଶିବା କଥା
ଏଇ PW1 କହୁଛି ପଶିବା କଥା ତେଣୁ ସେ ପଶିବାର ଆଚ୍ଛା PW6 କୁ ପଳେଇ ଆସନ୍ତୁ ଯିଏ କି କହୁଛି ମୁଁ ଛିଡା ହେଇଥିବା ଦେଖିଲି
PW6
page number 61
chief I know the accused persons 1 year back Sumitra was killed 1 year back after Raja festival Sumitra was killed by the accused Nilu due to previous ill feeling I had seen accused Nilu
ଇଏ ଯେମିତି କହୁନି ସେଇ ଟାଇପ ର ଏଭିଡେନ୍ସ ଟା ହବା କଥା ଯେ ମୁଁ ଦେଖିଲି ସିଏ ପଶିଲା ତା ଘର ଏ ଏଭିଡେନ୍ସ ଠିକ ରେକର୍ଡ ହେଇଛି I had seen
accused Nilu standing near the house of Sumitra in the night of occurrence
ଏଇ ଟାଇପ ର ଏଭିଡେନ୍ସ ଟା ରେକର୍ଡ
ଘର ପାଖରେ ଠିଆ ହେଇଥିଲା ଦେଖିଥିଲା then
ରାତିରେ ଛିଡା ହେଇଥିବା
ରାତିରେ ଠିଆ ହେଇଥିଲା ସେଇଟାକୁ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଏକ୍ସାକ୍ଟ ଟାଇମ
ଦେଇକି come to that you read it out
before the incident Nilu was inside the jail custody for charge of rape to the daughter-in-law of the Sumitra and after release from jail he killed Sumitra I was examined by the police my house is at a distance of 10 feet from the house of Nilu Nilur ଘର ପାଖ ସେ ସୁମିତ୍ରାର ଘର ନିଲୁ ଘର my house is at a distance of 10 feet from house of Nilu Sumitra constructed a house on the government land I cannot say if there was difference of opinion between Sumitra and Debo for possession of government land it is never a fact I had stated before the police that due to possession of government land there was gross ill feeling between Debo and Sumitra and 20 days before the incident Sumitra dug earth which was objected by Debo who threatened Sumitra and her family members to finish them I had seen accused Nilu standing near the house of Sumitra at about 1:30 a.m. in the night while I was going to attend the call of nature. I had seen none else other than accused Nilu. On the said night, Sumitra was killed. I have never stated before the police that on Saturday at about 2 p.m. afternoon, the accused Nilu standing in front of the house of Sumitra. It is not a fact that I am deposing falsely.
ତାମାନେ ସେ ଯୋଉ 1:30 ରହିଥିଲା ସେଇଟା that stands it is not a fact regarding ଖରାବେଳେ
ସେଟା ଟାଇମିଂ ଟା ଘର ପାଖରେ ଠିଆ ତା ଘର ବି ଆ ଘର ବି ତା ଘର ପାଖରେ 10 ଫିଟ ଦୂରରେ ତା ଘର
ସେ ଉଠିଥିଲା
ସେ ଘର ପାଖରେ ଠିଆ ହେଇଥିଲା
to answer call of nature so that relates
let us see that 161 ଟା ଦେଖିବା ଇଏ କଣ ରାତି କଥାଟା କହି ନଥିଲା କି ଏମିତି ପଚାର
ନାଇଁ କହିଲା ପରେ ନାଇଟ୍ ଅଫ୍ ଅକରେନ୍ସ କହିଲା ଆଉ ପଚାରିଲେ ଟାଇମ ଟା କହିଦେଲା ଆଉ କଣ
PW6 ର ନାଁଟା କଣ
PW6 ହଉଛି ଆନନ୍ଦ ବେହେରା ଚିଫ୍ ରେ କହିଲା ରାତିରେ ଦେଖିଥିଲି ଯେତେବେଳେ ପଚାରିଲେ ଟାଇମ ଟା କହିଦେଲା ଆଉ
ଆନନ୍ଦ ବେହେରା statement ହଉଛି ତାର ମାନେ occurrence day ର ଗତ ମଝି ରଜ ଶନିବାର ନୀଲୁ ଆସି ସୁମିତ୍ରା ଘର ପାଖରେ ଦିନ 2ଟା ସମୟରେ ଠିଆ ହୋଇ ପାଟି କରୁଥିଲା। ରବିବାର ଦିନ 9ଟା ସମୟରେ ସୁମିତ୍ରାର ପୁଅ ବୋହୂ ସୁଆଂଶୁ ଗ୍ରାମକୁ ବୁଲିବାକୁ ଯାଇଥିଲେ। ଦିନ ପ୍ରାୟ 1ଟାଏ ହେବ ନୀଲୁ ସ୍ୱାଇଁ ସୁମିତ୍ରା ଘର ପାଖକୁ ଆସି କେସ୍ ଉଠାଇବା ପାଇଁ କହିଥିଲା। ସୁମିତ୍ରା ରାଜି ନ ହେବାରୁ ନୀଲୁ ତାକୁ ଧମକ ଚମକ ଦେଇ କଣ କ୍ଲବ ଘର ପାଖାପାଖି ଯାଇ ବସିଲା। ରବିବାର ରାତିରେ ନୀଲୁ ସ୍ୱାଇଁ ସୁଆଂଶୁ କ୍ଲବ ଘରେ ଭୋଜି କରି ଖାଇଲେ। ସୋମବାର ଅର୍ଥାତ୍ କାଲି ସନ୍ଧ୍ୟାରେ ଦେବ ନୀଲୁ ସ୍ୱାଇଁ କ୍ଲବ ଘରେ ବସିଥିଲେ। ବସି କଣ କଥା ହେଉଥିଲେ। ରାତି 10ଟା ପର୍ଯ୍ୟନ୍ତ ସୁମିତ୍ରା ତାଙ୍କ ଘର ପାଖରେ ବାସନ୍ତୀ ମୁଦୁଲି ସହିତ କଥାବାର୍ତ୍ତା ହଉଥିଲେ। ଠିକ ଅଛି। 10ଟାରେ ସୁମିତ୍ରା ଶୋଇବାକୁ ଗଲା। ମୁଁ ମୋର ଘର ବାରାଣ୍ଡାରେ ଶୋଇଥିଲି। ମୋର ପାଖରେ ମୋର ସ୍ତ୍ରୀ ମଧ୍ୟ ଶୋଇଥିଲା। ରାତି ପ୍ରାୟ 1ଟାରୁ 2ଟା ହବ କୁକୁର ଭୋକିଲା। ମୋର ନିଦ ଭାଙ୍ଗି ଯିବାରୁ ମୁଁ ରାସ୍ତା ଉପରକୁ ଆସି ବୁଲାବୁଲି କରି କୁକୁର କାହିଁକି ଭୁକୁଛି ଦେଖିଲି। ହଠାତ୍ ସୁମିତ୍ରା ଘର ମଧ୍ୟରୁ ଶବ୍ଦ ଶୁଣିଲା। ମୁଁ କିଏ କିଏ କହିବାରୁ ହଠାତ୍ ନୀଲୁ ସ୍ୱାଇଁ ସୁମିତ୍ରା ସ୍ୱାଇଁ ଘରୁ ବାହାରି ଦୌଡ଼ି ପଳାଇଗଲା। ସୁମିତ୍ରା ଘର ପାଖରେ ଦେବ ଠିଆ ହେଇଥିଲା। ଏଗୁଡା କିଛି କହିନି ଅବଶ୍ୟ ଏଗୁଡା ମାନେ ୱାନ୍ସ ଯୋଉ ଏଭିଡେନ୍ସ କିଛି କହିନି। ନୀଲୁ ସ୍ୱାଇଁ ଦେବଦାସ ଘର ଆଜକୁ ପଳାଇ ଗଲେ। ସେଇ ସମୟରେ ସୁମିତ୍ରାକୁ ଧମକ ଦଉଥିଲେ ମୁଁ ସୁଆଂଶୁ। ସୋ statement ସିଏ 160 ମାନେ ଦିଥର କହିଛି। ଇନଫ୍ୟାକ୍ଟ ସେ ଗୋଟେ ହଉଛି ଖରାବେଳେ ଗୋଟେ ରାତିରେ ଗୋଟେ କହିଛି ଯେ ବାହାରିକିନି ପଳେଇ ଯାଉଥିଲା। ଏଠି କହୁଛି ମାନେ ମୁଁ ଦେଖିଥିଲି ଯୋଉ ତା ଘର ପାଖରେ ଛିଡା ହେଇଛି ରାତିରେ ଛିଡା ହେଇକି ଦେଖିଲା ବୋଲି ସେଠି ଅବଶ୍ୟ କହିଥିଲା ଯେ ରାତିରୁ ମୁଁ ଦେଖିଲି ତା ଘର ଭିତରୁ ବାହାରି ପଳେଇଲା। ରାତି ପ୍ରାୟ 1ଟାରୁ 2ଟା ହବ ସୁଆଂଶୁ ଭୁକୁଥିଲେ। ହଠାତ୍ ସୁମିତ୍ରା ଘର ଭିତରୁ ଶବ୍ଦ ଶୁଣିଲା। ମୁଁ କିଏ କିଏ ବୋଲି ହଠାତ୍ ନୀଲୁ ସ୍ୱାଇଁ ସୁମିତ୍ରା ଲେଙ୍କାର ଘରୁ ବାହାରି ଦୌଡ଼ି ପଳେଇଲା ଏବଂ ସୁମିତ୍ରା ଘର ପାଖରେ ଦେବ ଛିଡା ହେଇଥିଲା। ଦେବ ହାଜ ବିନ୍ ଆକ୍ୟୁଟେଡ୍, वी आर नॉट कन्सर्न्ड विथ दैट। ଏବଂ ନୀଲୁ ସ୍ୱାଇଁ ଓ ଦେବଦାସ କ୍ଲବ ଆଡକୁ ପଳେଇଗଲେ।
ଆଇଓଟା କିଏ?
Peter 20. This much the evidence.
କହୁଛି my investigation revealed that the accused had motive to commit a murder of the deceased.
No, see that is not admissible, but in view of the evidence on record that a rape case was instituted.
That the deceased was the eyewitness of that case.
No, ହେଇଥାଇପାରେ ମାନେ
ଆଇ ୱିଟନେସ୍ ଛାଡ, ସେ ତ ଫ୍ୟାମିଲିକୁ ମାରିବି କହିଛି ଆଉ। ତମେ ଯଦି ବିଦ୍ରୋହ କରିବନି ମୁଁ ତମ 3 ଜଣଙ୍କୁ ମାରିବି ବାସ୍। ସେଟା କୋଉଠୁ ବାହାରୁନି?
ନା ଆଇ ୱିଟନେସ୍ କି କଣ ସେଇଟା ଆପଣ ଯଦି ଆଣିକିନି ପ୍ରମାଣ କରେଇଥାନ୍ତେ ଏଇ ଟାଇପ୍ ର ଏଭିଡେନ୍ସ ହେଲା। ରେପ୍ କେସ୍ ରେ ମନେକର ବୁଢୀ ସାକ୍ଷୀ ଦେଇ ସାରିଥାନ୍ତ, ଯଦି ଦେଇଥିବ କି ସେତେବେଳକୁ ବୋଧେ ଟ୍ରାଏଲ ହେଇଥିଲା କି ନାଇଁ ଜଣା ନାହିଁ।
ଟ୍ରାଏଲ ହେଇନଥିଲା।
ସେ କହୁଥିଲା ବିଦ୍ରୋହ କରନ୍ତୁ, କେସ୍ ଉଠେଇ ଦିଅନ୍ତୁ। ସେ କହୁଥିଲା କେସ୍ ଉଠେଇ ଦିଅନ୍ତୁ ନହେଲେ
11 ମସିହାର ଇନସିଡେଣ୍ଟ ରେପ୍ ମାନେ 161
ହେଇଥିବ ମାନେ 161 ହବାକୁ ବାଧ୍ୟ।
ଚାର୍ଜସିଟ୍ କରିକି ରଖିଥିବ, ଖାଲି ସାକ୍ଷୀ ପାଇଁ ରହିଥିବ ବୋଲି ସେଟା ସେ
ହବ
it should have been proved that ଯୋଉ ଲିଙ୍କ ଟା କହୁନାହାନ୍ତି ଯୋଉ ଆଡମିଟ ମାନେ କେସ୍ ଟା ଇନଷ୍ଟିଚ୍ୟୁଟ ହେଇଛି ବୋଲି ତା ନାଁରେ ଆକ୍ୟୁଜ ବି ଡିସ୍ପ୍ୟୁଟ କରୁନି ଯେ ରେପ୍ କେସ୍ ହାଜ ବିନ୍ ଇନଷ୍ଟିଚ୍ୟୁଟେଡ୍, ଭିକ୍ଟିମ୍ ଇଜ PW9 these are things are not being disputed. जो एटा जो पुलिस कहिची, in addition to that, the 161 statement of the deceased given in that rape case should have been proved by the prosecution. The सीउची eyewitness जो आपण कहउछन बाजार ସେଥିପାଇଁ ସେଟା ବୋଧେ ପ୍ରମାଣ ହେଇନି ସେ ତା statement ବୋଧେ ଆସିନି so
These are the circumstances, my lord. And from the IO evidence, my lord,
IO say that 27 they are careful say rape case ta posting kala daily time.
27
2013 just incident hala
incident is ରଜ
June ମାସରେ
जुलाई ମାସ ଥିଲା posting
ସେ ପରା କହୁଥିଲା କେସ୍ ଟା ଉଠେଇ ଦିଅ ପରା ସେଥିପାଇଁ କଣ କହୁଥିଲା
that is the ସେମାନେ ସେଇଥିପାଇଁ ତ କହୁଛି କେସ୍ ଟା ଉଠେଇ ଦିଅ ବୋଲି that was the motive behind the crime ବୋଲି prosecution case ହଉଛି ସେ
ଉଠେଇ ଦିଅ ଆଇଓ ଗୋଟେ କହୁଛି ସେଟଲ୍ କରିଦିଅ but
so
another thing is what is the so far the report exemption report that say that on 7 and 8 that two report Bambo he can that Horika
କୋଉଥିରେ ମିଳିଲା
that which was seized by the police
କୋଉଠୁ
that I read that statement of the police
ନାଇଁ आ instance ରେ ଦେଇଛି ନା ଏମିତି
spot ରୁ ମିଳିଲା that was relevant.
Nobody
even box squad was utilized by the IO, no incriminating or nothing.
ନାଇଁ ଏଇ କେସ୍ ରେ ଆପଣ homicidal death କି dispute କରୁନାହାନ୍ତି. He is also not disputing that is the finding. ଆପଣଙ୍କର circumstance एक होची motive, ଦୁଇ होची threat, तीन होची एक नंबर साखी ଘରକୁ ପଶିଲା, ଚାରି होची 6 नंबर साखी ବାହାରେ ଛିଡା ହେଇଥିଲା. ଏତିକି ତ ଆଉ କଣ ତେଣୁ ଯଦି ଏକ ନମ୍ବର ସାକ୍ଷୀ ଯଦି ଆଇ ୱିଟନେସ୍ ନୁହେଁ ହିସାବରେ କହୁନି ଖାଲି ଗୋଟେ ଜେନେରାଲ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଛି ଯୋଉ ଘରକୁ ପଶିବା ଏଇଟାକୁ ଯଦି କାଟି ଦିଆଯାଏ ତାହେଲେ ଆଉ ବାକି ରହିଲା PW6 ଘର ପାଖରେ ଛିଡା ହେଇଥିଲା ଆଉ ଟାଇମ ହଉଛି ରାତିରେ
third party is concerned or other evidence
third part ଅଛି third part ଅଛି
9-12 କହୁଛନ୍ତି ଆଉ ବହୁତ ଅନ୍ୟ ଜଣ ବି କହୁଛନ୍ତି
ଏଇ ଯେତିକି circumstance whether it would make the chain complete threat ଦିଆ ହେଇଥିଲା ଥିଲା ଆଉ ବାକି ରାତିରେ ତା ଘର ପାଖରେ ଛିଡା ହେଇଥିଲା ଏତିକି ହେଲେ chain complete ହେଇଯିବ can it be said that there is no escape from the conclusion that it is the accused and accused only who has committed the crime ଏଠି ଆପଣଙ୍କର ୟାର ତ ମୋଟିଭ ଥିଲା ସେଇ ଆର ଗୋଟେ ଲୋକର ଦେବର ମଧ୍ୟ ମୋଟିଭ ଥିଲା ତା ଜମି ନେଇଥିଲା ବୋଲି ତେଣୁ ସେ ପାର୍ଟଟା କିଏ କହିଛି
PW6 IO has also admitted and other witnesses
ନା witness ଗୁଡା ଦେବକୁ ପରା implicate କିଏ କଲେନି
ପାର୍ଟଟା ବୋଧେ ଏଇ ଯୋଉ ମୋଟିଭ ପାର୍ଟଟା ବୋଧେ ଦେବ ନାଁରେ କିଛି ଅଛି କି who has stated like that paragraph 18 ne koichi PW22 it is IO evidence there was previous dispute with the accused Devadas and the deceased Sumitra in connection with the land eta gote line IO kochi but se kochi je au ki sakhi ko se bisare
se sakhi को suggest होइछि PW6
PW6
आइए PW6 which is
from the house Mr. constituted house on the government land and cannot state different document within the Mr. and the for possession of the government. The neighbor attacked that I had stated before the police that due to
ତୁମେ ମନା କରୁଛ ଆଗ କହିଥିଲ ତ
government land, there was a increasing between the one.
ওই ଜିନିଷଟା କହିଥିଲା ପୋଲିସ ପାଖରେ ତା ବାହାରକି ଇଏରୁ ପ୍ରୁଭ ହେଇଛି ଆଇଓ ଥ୍ରୁରେ
ଆଇଓ ଥ୍ରୋରେ ଆଇଓକୁ ଦେଖିଥିଲା ଆଇଓ ଏଭିଡେନ୍ସ ତାକୁ ପଚାରେ ଆଇଓ ନିଜ ତରଫରୁ ଖାଲି ଏଭିଡେନ୍ସ ଆଡମିଟ କରିଛି
ମାନେ ଏଇ ଯୋଉ ଲାଇନରେ ଇଟ୍ ଇଜ ନେଭର ଏ ଫ୍ୟାକ୍ଟ ଦ୍ୟାଟ୍ ଆଇ ହାଡ୍ ଷ୍ଟେଟେଡ ବିଫୋର ତାମାନେ ତମ ପୋଲିସ ପାଖରେ କହିଥିଲ ଯେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲ୍ୟାଣ୍ଡର
ସେଇଟା ମୁଁ
ପଜିସନ ପାଇଁ ଦେବ ଆଉ ସୁମିତ୍ରା ଭିତରେ ଏମିତି ଗଣ୍ଡଗୋଳ ଥିଲା
ପିଡବ୍ଲ୍ୟୁ ସେ ଲାଇନଟା ପିଡବ୍ଲ୍ୟୁ 6 କୁ ରେଫର କରିକି କରାଏନି ଖାଲି ଆଇଓ ପିଡବ୍ଲ୍ୟୁ 18 ପାରାଗ୍ରାଫ 18 ଖାଲି ଆଇଓ ନିଜ ତରଫରୁ କରେ
ଜେନରାଲ
ସେ ଲାଇନଟା ପିଡବ୍ଲ୍ୟୁ 6 ର
PW6 ର 161 ଅଛି ସେ ବିଷୟରେ ସୁମିତ୍ରା ଘର ପଛରେ ଦେବଦାସର ଚାଷ ଜମି ଅଛି ସୁମିତ୍ରା ଘର କରିବାକୁ ଦେବ ଜମିର ମୂଲ୍ୟ କମିଗଲା ଅନେକ ସମୟରେ ଦେବ ଆସି ସୁମିତ୍ରାକୁ ଗାଳି ଗୁଲଜ କରି ସେଠାରୁ ପଳାଇ ଯିବାକୁ ଧମକ ଦେଇଥିଲା 20 ଦିନ ତଳେ ସୁମିତ୍ରା ତା ଘର ପଛପଟରେ ମାଟି ପକେଇବାକୁ ଦେବ ଆସି ସୁମିତ୍ରାକୁ ଗାଳି ଗୁଲଜ କରି ତାର ମାଟି ପକେଇବାକୁ ବନ୍ଦ କରିଥିଲା ସେ ଜୀବନରେ ସୁମିତ୍ରାକୁ ତା ପରିବାରକୁ ମାରିଦେବାକୁ କହିଥିଲା ତ ଇଟ୍ ଇଜ ନଟ୍ ଦ୍ୟାଟ୍ ଏଇ ଯୋଉ ଜିନିଷ ଖାଲି ପଚାରିଥାନ୍ତେ ଆଇଓକୁ ପଚାରିଥାନ୍ତେ ସେ ବିଷୟରେ ପଚାରିନାହାନ୍ତି ଇଟ୍ ଇଜ ଦେୟାର ତେଣୁ you can say that not only the appellant but also Devo had also given them threat ये ଦେଇଛି ଗୋଟେ କେସ୍ ପାଇଁ ସେ ଯୋଉ ରେପ୍ କେସରେ ତମେ ଉଠେଇ ନିଅ ଆଉ ସିଏ ତାର ଲ୍ୟାଣ୍ଡେଡ ପ୍ରପର୍ଟିଜ ନେଇକି ଯୋଉ ଡିସ୍ପ୍ୟୁଟ ରହିଛି ତାକୁ ମଧ୍ୟ ସେ କନେକ୍ସନରେ ଥ୍ରେଟ୍ ଦେଇଛି
କୋଉ ୱିଟନେସ୍ କହୁଛି ସେଟା
ଏଇଟା PW6 ଆନନ୍ଦ ବେହେରା ତ କନଫ୍ରଣ୍ଟ କରିଛନ୍ତି ନା ଏଇ ଯୋଉ
ମନା କରୁଛୁ ତ
it is never a fact it could have been proved through the IO through a ପ୍ରମାଣ
ଷ୍ଟେଟ୍ ଡିଫେନ୍ସ କାଉନସିଲ ପଚାରିନାହାନ୍ତି ଆଉ
ତେଣୁ yes what is your submission now Mr. Nayak and Mr. Jafurullah.
My submission with your lordship, this apart from the motive, lordship, motive only cannot cannot be the basis, even strong motive that cannot be the basis of the conviction if there is no other circumstances. So here, the other two circumstances apart from the trial court has taken note of the PW1's evidence and PW6. PW1's evidence cannot be accepted, that is that he had seen the occurrence, he had seen the accused entering into the house, and thereafter, and then so far the PW6 evidence, merely presence in the spot at the near the house. It cannot be construed as a circumstances that he has entered inside the house and committed murder. Furthermore, IO during investigation and the prosecution did not find any piece of material, though he utilized the dog squad and nothing. During no piece of material from the inside the spot, any incriminating material to connect the appellant, either from the wearing apparel or from the spot, from the fingerprints or anything. So there is no other material to connect the appellant. This.
So even if we accept that evidence of PW6 that he had seen the presence of the appellant
near the
house in the night of the occurrence. So, according to you, this circumstance coupled with the motive and threat that would not be sufficient to form the chain complete. That is your
completion of chain.
When were you arrested? How many days after the occurrence you are absconding?
Arrested.
Because the IO says, paragraph 21, on 2/8/2013 as he remained absconded after the occurrence.
He arrested Rabindra on 20/6/2013.
Paragraph 21, he says, I arrested accused on 2/8/2013.
I arrested accused Nilu on 2/8/2013.
So, any citation you have? Give it by tomorrow.
Name of citation I will give regarding notice.
Citation on all these points you give it. Motive, then about this thing. It cannot be, of course, said to be last seen. He was present outside.
Outside.
It is not a last seen.
Last scene.
Presence of the accused outside the house of the deceased in the odd hour of night.
That also must have been put to him. What did he say? Micha?
Micha.
Yes, Mr. Naik.
No. I'm sorry. 13 number PW6 13 number question
Micha kata hai.
What is this question that has been put to him?
PW6 has stated that he suspected your involvement in the murder of the deceased.
As he had seen you standing. He had seen you standing.
You standing near the house of the deceased
at 1:30
a.m. in the relevant night of occurrence.
What do you say?
What do you say?
Yes, Mr. Naik. So, the fundamental principle while appreciating the case based on circumstantial evidence is that suspicion, howsoever strong, cannot take the place of proof. Number one. Number two, that there is a portion of difference between may be true and must be true. There is no place of surmise, supposition in a criminal trial. He might have committed the murder or this. So, if you are to prove the case by way of a circumstantial evidence, then that Panchashil, which has been stated in that 84 Supreme Court, Sarad Vilchan Sarda, a case of principle explain ଆପଣଙ୍କୁ ରଖିବାକୁ ପଡିବ ତ ଯେତିକି ତିନିଟା circumstance ଯଦି ଆସିବ ଯେ ତା ନାଁରେ ଗୋଟେ rape case thila, and the victim was the daughter-in-law of the deceased. Number one. Number two, there was continuous threat. You can say that. Let us use that word, continuous threat, given by the appellant to the deceased and also to the victim, and to withdraw the case. And on the date of occurrence, in the night at about 1 o'clock, the appellant was found standing outside the house of the deceased. These are the three circumstances. Because number one's evidence, it is very difficult to accept because he has not stated that I have seen the appellant entering into the house of. So, what is your submission that how you say that the chain has been made complete, so that if these three circumstances are taken into account, apart from the fact that these are not disputed, homicidal death, ଆଉ ସେ ବାଡି ସେଠି ପଡିଥିଲା ଏଗୁଡାକ ସେ dispute କିଛି କରୁନାହାନ୍ତି ବା ତାଙ୍କର ଏଗୁଡାକ ନହେଲେ ବି ଏଇ ତିନିଟାରୁ ଆପଣ କେମିତି ଇଏ କରିବେ?
The third party is concerned that
So
the third party is concerned. That is they are all the witnesses and the deceased and as well as the victim also stated that earlier was the said as because on the earlier case of the rape case. And the PW6 also stated that he is standing in front of the deceased house at the midnight. So only question is that part has not been clear whether so far the PW1 is concerned, their evidence is not clear as like as the evidence of the PW6.
PW6. He has not stated I have seen.
Only the PW6 is stating that I've seen that the accuser is standing in front of the house of the deceased in the midnight. And in the police, before the police, they are saying that
we cannot take into account. We cannot rely that 161 statement as substantive evidence. Just the court has its power to also see that 161 statement, but we cannot utilize it like that. I mean, to ascertain the correctness of the, we can see it. There is no restriction that we cannot even peruse it. Perusal and use of that statement is two different things, right? So, say 161 रे एगुड़ा को कहिथिला तो कहिथिला आ कोन प्रथम कोर्ट रे तो सेगुड़ा कहूनी ना कि आपण जदी सेगुड़ा को कहिथिला and he was omitting that in the court, then prosecution should have also put some question declaring hostile that you have stated that you have seen the accused was coming out of the house. That has not been made, and it should have been also proved through the IO. ଆପଣ PW6 को पचारि थांते जे बाबू देखो तुम जेतले पुलिस पाखरे जमानबंदी देलो तमे कहिथिलो जे तमे देखिचो जे सिए घरु बाहरी किनी पळे आस्तेला
He was not declared hostile also.
ना सीएफ से हैं ये सेटा जदी कहि थांते एवं पुलिस टू आनी थांते we could have looked into it, but Vatan says प्रश्न ही नहीं. Only evidence remains that PW6 stated that he was found standing, right? You know, Give, if any citation you want to give, you can give it by tomorrow. We are reserving the judgment. Our Mr. S.K.Sahoo, Land Counsel for the appellant, and Mr. Jateshwar Nayak, Land and Additional Government Advocate. Mr. Jafrullah files a synopsis of the case, which is taken on record, and he submits that he will file a memo citation by tomorrow. Land Counsel for the state also submit that he will submit some citations tomorrow. Hearing is closed, judgment is reserved.
Your pardon, my lord. My lord, supplementary item number 5. Your lordship has engaged me. Let me take a copy of the paper book from the court master. Again, data paper book actually said.
Order he five key
Again, supplementary item.
You tell them that I'll receive item number 5 is a portion add for them. Get a copy of the paper. Are you sure that number 5 paper book has been prepared?
Yes, my lord. It is a noting. This set paper.
हाँ ठीक है गोटे पेपर दे देबे ऑर्डर शीट रे 10 10 होई है ना
God bless you.